Seats. The clerk will call the roll. Please vote aye if you're here.
No if you're not.
No if you're not. We have a quorum, 10, 0, and 0. Okay, first of all, thank you for coming, and I hope everybody will be civil and listen to each other, whether you agree or not. First of all, we have Senate Bill 378, Senator Bell's bill, computer trespass bill. It will be sent to the Criminal Law Subcommittee, and I believe it's similar to Senate Bill 844, which is already in Criminal Law Subcommittee. And Senate Bill 1091, Senator Stanley's bill, authorization of volunteer school security officers by local school boards and private or religious schools be re-referred to the Senate Committee on Education and Health.
So moved.
All in favor for the motion, say vote aye. All opposed, no. As 10 to 0, the Senate Bill 1091 will be re-referred to Education and Health. We have two bills been requested to go by for the day. Senate Bill 359, Senator Cosgrove's bill regarding gifts of real estate. Without objection, that will go by for the day at the request of the patron. Senate Bill 607, Senator Norman's bill regarding Virginia Public Procurement Act, statute of limitations. That bill will go by for the day. Senate Bill 607, without objection, by for the day.
Mr. Chairman?
Yes.
Senator Cosgrove, Senate Bill 195 is identical to Senator Norman's 607, so that one should also go by for the day.
That's correct. Senate Bill 195, Senator Cosgrove's bill, which is identical, will go by for the day as well. Okay. Now, are we ready to hear some bills? Senator Favola is here. She has Senate Bill 105, the best interest of the child. Senator? Yes, Senate Bill 105.
Thank you, Mr. Chairman. I do have an amendment. The last time I presented, we talked about the definition of intimate partner. I worked with our stakeholder group. We found a definition in federal code, so if you'd like to distribute that.
Okay. We have this is a substitute or a line amendment?
And you already took comment at the last meeting, so I don't have any, I didn't ask any speakers to come.
Okay, you want to explain what this bill does?
What this bill does is it attempts to articulate a criteria that we want judges to consider when determining what's in the best interest of a child, both for custody and for visitation. And so we talk about intimate partner abuse. We talk about child abuse and intimate partner violence against an intimate partner, I guess, is how we would word it.
Yeah. Is there a motion that we adopt the line amendments? Is there a motion we adopt the line amendments? So moved and seconded. All in favor of the motion to adopt the line amendments, say aye. Aye. All opposed, no. The motion is adopted.
Mr. Chairman.
Senator Shervill.
Sorry, maybe I should have brought this up before we just voted. But speaking to the bill, you know, we had a lengthy discussion on this bill last time it was up. And I reviewed the bill and I gave council some amendments that I would support. My primary concern about this bill is that we have a statute here that's worked well for decades. And I think there's not a lot that needs to be changed. To the extent there's a hole in this area, it seems to me that because this is focused on child custody and visitation, that if there's a history of child abuse, that ought to be something that a court can consider beyond the last order. But getting into this intimate partner violence, which could include things that happened in college 20 years ago, I think is a really dangerous thing to get into in custody cases. And so I gave council a line amendment which would say, we just simply add a history of child abuse to this statute and delete the rest of this out of this bill. And if we made that amendment, I would feel more comfortable with the bill. And I've talked to the patron about it.
Mr. Chairman,
Yeah, Senator Norman.
ditto.
I just spoke to Senator Serville. I am very happy with that amendment, so I guess we would have to move Senator Serville's amendment, which would make my intimate partner definition moot, which is okay, and bring out child abuse. I would just argue that the Committee on Sexual Assault, actually committee that the General Assembly created, actually heard a lot of testimony arguing that there is a gap in our current statute. So anyways, I'm very happy with the suggestion by Senator Serville and Senator Norman.
Is there an amendment, though?
Mr. Chairman?
Yeah, Senator Serville.
Thanks. I think procedurally, we'd have to unwind the amendment we just did and then make the line amendment I gave to council. And so having said that, I think I vote on the prevailing side. I move to reconsider the vote by which we just adopted the line amendments.
All right, the motion has been made to reconsider the vote by which we adopted the line amendments. All in favor of the motion, say aye.
Aye.
All opposed, no. All right, been reconsidered.
That's not a recorded vote.
Not recorded vote, no. No,
And
just,
Mr. Chairman, then I would move the line amendments that I gave to council, which you can read.
all right, where are the line amendments?
Council.
Mr. Chairman, it's the first two amendments that I handed out from Senator Favola, which we had talked about at the last meeting. So it was to add on line 5, history of child abuse, after the word child, and on line 36, after of, insert child abuse or, and then strike all of the italicized new language relating to intimate partner.
So the definition of intimate partner would not be in there, is that what you're saying?
Correct, Mr. Chairman.
Okay, all right, so it's the first two line amendments on the handout, but not the third one. Is that correct?
Yes, and then
Mr.
to
Chair.
strike all
Senator
of the
Deeds.
italicized language.
Kristen, if I can understand, then all the italicized language in paragraph 9 on lines 34 through 36, that's gone as well, is right?
Yes, all that would be left would then be history of child abuse.
Okay.
Okay. All right, we understand it? Is there a motion to adopt the new line amendments?
So moved.
All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Senator Favola, you have anybody who wants to speak?
Being respectful of your time, I have asked my speakers not to come to the podium. I am very satisfied with that amendment, so I would hope it's the pleasure of the committee to now adopt as amended.
There's a motion to report. It's been moved and seconded that the bill be reported as amended. All in favor of the motion, vote aye. All opposed, no. Ayes 11, noes 0. Thank you, Senator Favola. You have another bill.
Thank you,
Senator
Mr.
116?
Mr. Chairman, Senate Bill 116, what this bill does essentially is it removes the death penalty as a sentencing option if a person is found to be seriously mentally ill at the time the crime was committed. We define severe mental illness, has the exhibition of active psychotic symptoms that substantially impair a person's capacity to really understand the nature of his or her actions. This bill in no way removes a life imprisonment. It only removes the death penalty as a sentencing option. And then there are processes on, how severe mental illness can be presented to the court and documented. And I respectfully ask that the bill pass. This is something the committee heard last year and the year before, although I understand we have new committee members.
Okay, is there any question to the patron? Senator Morsi?
Mr. Chairman, go ahead.
Senator Morsi.
Mr. Chairman,
Senator Morsi.
he's deferring to me, I think.
I'll defer to
Okay, Senator Serville.
So, Mr. Chairman, we also have my bill to abolish the death penalty. Shouldn't we take these up at the same time?
Well, this is different. Yeah, this is different. We'll just take it up.
Okay, all right.
Okay,
Okay.
go ahead. Who would like to speak? 3 minutes apiece? Yeah, Senator Morsi.
Question for the patron.
Yes.
This bill provides that when the defendant has a severe mental illness, a determination regarding the specifics of his mental illness will be taken up as part of the sentencing proceeding. My question is, does that mean it will not be taken up during the case in chief? And as you know, right now, we don't have gradations for mental illness. You have not guilty by reason of insanity, and then nothing going up to that. I love the bill because it gets
It's a middle
this in
ground.
front of the jury as part of the sentencing process, but I want to, and I see some folks shaking their head behind you, maybe. I want to know if it at all considers it during the case in chief.
I think a practitioner would be better
Good morning,
prepared to
Senator.
answer
Doug
that.
Ramsor. I spent 10 years as the capital defender for Central Virginia
Yeah.
and Southeastern Virginia.
State your name.
My name is Doug Ramsor.
Speak to the committee.
Thank you. And I spent 10 years as the capital defender for Central Virginia and Southeastern Virginia. I've represented more than 30 people charged with death penalty offenses. This bill tracks in the same way that we do for intellectual disability right now, which means it is part of the sentencing proceeding. It doesn't come in the case in chief. It would be a sentencing issue that gets presented to a jury only after a person has been convicted of capital murder, and then it gets presented at that time.
Mr. Chair.
Okay, Senator Peterson.
Okay, and I sort of a series of questions, but so it occurs during the sentencing. Who has the burden of proof? Who pays for the experts? When is this done? Because it seems like this inquiry alone could take months.
So this the burden of proof is on the defendant to prove it by a preponderance of the evidence, in the same way it is with intellectual disability. It is also an expert is to be appointed to represent for the defense to do an examination as well as for the prosecution if they've noticed to do that. That analysis can be combined, its language is in the statute, with the psychological analysis that are already mandated in the code. Those for a forensic psychologist under 19.264.3:1, as well as for competency, as well as for intellectual disability. So potentially one expert could deal with all of these issues in the same evaluation, be prepared to testify.
For follow-up question, Mr. Chair.
Yeah, Senator Peterson.
And would this take place before the trial or after the trial and before the sentencing?
This would almost always happen before the trial, although the language of the bill says something about after conviction. This is always going to happen pre-trial.
Right.
This is something that has to be raised at least 60 days before trial to give notice
Right.
that way. And so a defendant, their counsel is going to make a motion for this expert to have the evaluation done prior to trial.
Okay, all right.
Any other questions? Okay, anybody else want to speak?
I do have a question,
Yes.
and it may be
Steve.
that Doug can answer it, Mr. Chairman, or one of the other speakers. I don't know if the patron intends for the bill to cover dementia as well as psychosis. And if so, then the question would be whether the bill is broad enough to cover dementia. But the patron may not wish
That
to
was
do
not
so.
my intent. No,
Understood.
no. We were very specific on our definition of severe mental illness, and we want to keep it that way. I mean, we're looking at psychosis and other very serious
Understood.
mental
No further
illnesses.
questions, then.
Okay, anybody else want to speak? You got 59 seconds. Go ahead.
Good morning, Mr. Chairman. Alexander McCauley, on behalf of the National Alliance on Mental Illness, we support the bill and thank Senator Favola for her work for many years. It's the exact same bill that was reported out last year.
Senator Norman? No, okay. Next. Okay.
Chairman, committee members, my name is Jenny Skatine. I'm with the Disability Law Center of Virginia, and we support the bill.
Okay,
Thank you.
Thank you. Next.
Yes, good morning. Bruce Cruiser with Mental Health America, Virginia, the Mental Health Association. We support the bill.
Okay. Thank you.
Morning, Mr. Chairman. Tom Antorcio, Virginia Catholic Conference. We support the bill.
Okay, next. Thank you. Yeah.
In opposition?
Okay, any in opposition? Speak up.
Yes.
Okay.
Good morning, Mr. Chairman and members of the committee. My name is Brian Haskins. I'm the Commonwealth Attorney for Pittsylvania County, Virginia. I'm here speaking on behalf of the Virginia Association of Commonwealth Attorneys to announce that we are opposed to the bill. Our concern with the bill is that the language is not tight enough, and the issue is going to be trying to decide an issue that's the DSM manual doesn't even address. There is no definition in psychology for severe mental illness within the DSM. Our problem with this is that the issue is already going to be in front of the jury through the other statutes that have been mentioned. But in this particular issue, we are concerned that it will apply specifically, for example, to individuals who are serial killers, such as Charles Manson or Jeffrey Dahmer or Ted Bundy, because those individuals have already been deemed to have had mental illnesses that would render them less likely to understand the nature and consequences of actions. But it would not apply to the ordinary individual, all these crimes are always extraordinary, who would be involved in a robbery and a murder, for example. And it would grant greater protections to the individuals who are in that area. Our other issue is that this is a step into admitting diminished capacity, which is something that our courts have never done in 400 years. We have a bright line standard of sanity or not sanity. And on the issue of capital sentencing, we do already have admission of mental health evidence because many experts are already appointed. And to address another question that was asked, I believe by Senator Morrissey, the Commonwealth would pay for these experts on almost every case because they are generally involved with capital clients being indigent clients. The government bears that burden. I can tell the court that these things will be, the committee, you was talking to the court, that this matter will be dealt with if you pass this bill pre-trial. The last capital case I was involved in took 5 years and had 168 pre-trial motions. This would just add to that number of motions that we would have. But these issues are heard and vetted before the actual sentencing proceeding. And in fairness to the patron, this is not something that would be brought up in the guilt or innocence phase. It would be brought up only in sentencing, but still for the reasons I've already stated, the Virginia Association of Commonwealth Attorneys is opposed. Thank you for your time.
Okay, thank you. All right, 34 seconds. Senator Morrissey.
Question for the Speaker, Mr. Chair. You realize, as you just pointed out, that this is not the defendant's issues regarding the defendant's severe mental illness isn't coming up during the case in chief unless he's entered or she enters a plea of not guilty by reason of insanity. We agree that, right?
Yes, Mr. Chairman, Senator Morrissey, that is absolutely correct. It's not a diminished capacity issue. This bill does not introduce diminished capacity for guilt or innocence phase.
Which is an issue for another day, and someday I'll get there. But tell me specifically why the Association of Commonwealth Attorneys is in opposition to Senator Favola's bill that issues surrounding severe mental illness, irrespective of whatever pretrial motions came up, shouldn't be brought up during that sentencing phase.
Mr. Chairman, Senator Morrissey, and I don't want to belabor my time too much. The point of the matter is these issues, we already have experts appointed to deal with mental health stressors at the time that the individual committed the capital act. To put into place a determination that requires a jury to make a factual finding that an individual should not face the penalty because they meet this standard, when the standard itself is not defined by the DSM, is one of the issues that we have.
All right, thank you, Mr. Chair.
I thank you for the question, sir.
Okay, thank you. Next speaker.
Good morning. My name is Jerry Gibbons. I was the executioner for the state of Virginia for 17 years. I've executed 62 people. Out of some of those 62, a lot of those guys were mental ill people. I prepare a guy 15 days before his execution date. On the date of his execution, I would know for a fact whether this man is ready for his next destination. I had several guys that come to me. Morris Mason, who committed a horrible crime where he raped, sodomized, and killed an old lady at 86 years old. But the date of his execution, to see whether he was ready or not, I noticed that he wasn't ready because he ordered McDonald's food. And he said, "Captain, put this in the refrigerator until tomorrow. I can't eat it all tonight." So he didn't realize that he was going to be executed, that this was his last day on earth. Another guy came, but he wasn't executed. But this guy had an IQ of 69. His name was Earl Washington. Come to find out that he was innocent. You know, before we sentence these people to death, we need to make sure that we screen them real good, because once they're gone, they're gone.
You support or against the bill?
Sir?
Do you support the bill?
Yes,
Okay,
yes.
All right.
100%.
Thank you.
You know, put yourself in my position as the one to carry out an execution.
Thank you very much.
you.
We appreciate your testimony, okay? Senator Favola?
Well, I will just say, I think the point was made that juries can already use this as an option. They can choose life in prison rather than the death penalty, depending on direction from the judge. What this does is make a policy statement about where the Commonwealth is on this issue and would ensure uniformity throughout the Commonwealth. And you know better than most, because this committee hears testimony in this area, but the Supreme Court has twice, both for youth and for those with diminished mental capacity, they argue that culpability is a very key factor in whether or not the death penalty should be applied. And my bill fits that construct, that analytic construct, where these individuals really don't understand, and I'm saying they should not be put to death, but life imprisonment. Under not guilty by reason of insanity, they're oftentimes sent to a mental institution and sometimes released. So that's a very different category than my bill.
Okay.
So I think you probably understand the issues. I think it's a needed policy, and I respectfully ask that you pass
Is there
it.
a motion to report? Yeah, Senator Norman.
Mr. Chairman, the first question is, I didn't follow you. You said something to the effect that they don't understand. What do they not understand?
Well, if a person has severe mental illness, I think by definition, the person does not understand, he doesn't exercise rational judgment in relation to his conduct, nor does he understand the consequences, according to definitions that are identified and promoted by various groups working with these individuals.
Mr. Chairman,
Yes,
knowing a little
Senator
bit about
Norman.
this, I haven't tried as many as this gentleman, but when I came to the General Assembly, I'd tried more capital murder cases than any lawyer in Virginia. And if they don't understand the consequences of their acts and stuff, that's a totally different deal than what you're talking about.
Okay. All right.
My second question, Mr. Chairman, is if in fact the Commonwealth is going to provide for the expert witnesses in this to make the determination on whether or not they can prove this mental illness by a preponderance of the evidence, how is there no fiscal impact?
All right, Senator Boyce? No, okay. Anybody else have a?
I'd like an answer.
Okay. Does somebody want to answer that question?
Excuse me, Mr. Chairman, Senator Norman, on the fiscal impact, several groups have done an analysis, and it is actually less expensive with a life imprisonment sentence than it is with the death penalty because of all the appeals that are inherent in our due process system. I can get you some resource citations if that's your question, or I can defer to staff. They may have a better answer.
If I can speak to the senator's point about certainly competency, and there is a concern with someone who's not competent and can understand and appreciate the criminality of what they've done. This bill doesn't speak to competency because it deals with someone who was not rational at the time of the offense. It could be someone who was untreated for a mental illness, and that's what substantially impaired their ability. They get arrested and they then get treated. They get sent to Central State. They get treatment. They then become competent to stand trial because they understand what's happening. But at the time of the offense, the severe mental illness was such that they couldn't do that. So these are very different things. A person might not be competent.
Senator McDougall.
Doug, before you go away,
Yeah.
there's some people that would argue self-ingestion of a narcotic like heroin or cocaine is because of a disease or illness and the self-consumption of alcohol. So if somebody goes out and is using heroin, would they not fit that definition you just described?
They would not. They're specifically excluded in this statute.
Line 51.
Voluntary intoxication of drugs or alcohol will not qualify you under the severe mental illness and psychotic symptoms for that.
It's in line 51.
Mr. Chairman?
Yeah, Senator McDougall.
If I'm addicted, am I voluntarily doing it? Isn't that a compulsion that I'm not able to control?
I don't think that's certainly not, I think, encompassed by the statute. I don't think anyone would read it that way.
Right, okay. Any motions to report? It's been moved and seconded to report the bill. We did report it out last year. All in
Pass the
favor of
Senate.
the motion, vote aye. All opposed, no. Ayes 9, noes 4. The motion is reported.
Thank you very much.
Thank you very much. Next bill, first of all, let me say.
Mr. Chair, I move that we strike at Senate Bill 574 at the request of the patron, Senator Mason.
Is there a second? All in favor of the motion to strike Senate Bill 574 regarding protective orders, Senator Mason's bill. All in favor of the motion, vote aye. All opposed, vote no. Clerk?
Ayes 13, no 0.
Ayes 13, noes 0. The bill is stricken from the docket.
Mr. Chairman,
Yes, Senator Obenchain.
Senator Donovan has Senate Bill 571, and she said that she got maybe late notice of that bill and had witnesses she wanted to bring, and asked me if I would ask if you would kindly take that by for the day.
Okay, Senate Bill 571 will go by for the day at the request of the patron, Senator Donovan. Okay? All right, Senate Bill 550, Senator Bell's bill, dating relationships abuse penalty. Request that go by for the week. So the motion, without objection, Senate Bill 550, Senator Bell's bill will go by for the week. Okay. Any others? Okay. All right, the next bill is Senator Stewart. Senator Cosgrove. Senator Cosgrove. Okay.
Good morning, Mr. Chairman.
Yeah.
Members of the committee. Mr. Chairman, I only have one bill left for you today because you were kind enough to pass by or roll in the other two bills that I had. Mr. Chairman, I have Senate Bill 197 for the committee's consideration. Mr. Chairman, this bill would actually increase the penalty for an oral threat made to a person, causing them to believe they were about to experience bodily injury or death. Currently, under the law in 18.2-60, if I communicate to you via phone or computer or text that I'm going to kill you, I'm going to kill one of your family, I'm going to hurt you, hurt one of your family, it is a Class 6 felony. However, if I come to you person to person and orally tell you the same thing, it's a Class 1 misdemeanor. So why do I bring this? We had an issue in the Portsmouth's Commissioner of Revenue office. One of the ladies there at the kiosk was trying to help a customer. The customer said, you know what, I'm going to wait outside, and when you come outside, I'm going to blankety blankety blank. All right. Put that person at great unease for fear of her life. They went to the magistrate's office. He looked up the code and said, hey, best we can do is a Class 1 misdemeanor, and we both know that that's not going to go too far. So what this bill would do is actually just equalize the code between an oral threat, which I believe is more intimidating than a threat via text or an email or Facebook or something like that. We both know that the social media makes it a lot easier for people to get a little more comfortable with making threats and making statements like that. So that's the crux of the bill, Mr. Chairman, and I hope the committee will consider it.
Senator.
Yeah, Senator Peterson?
Peterson.
Yes, sir.
As I understand, this strictly has to do with school property, correct?
I don't believe it's just school property, Senator. It includes school property, but it just says be orally made to any person in 18.260.
Okay.
I may have missed.
Okay, all right. Okay, yeah, I'm getting some legal advice in my right here. So the first paragraph is not school, and then the second paragraph is schools.
Right.
Okay, follow-up question?
Yeah, Senator Peterson.
And I guess, particularly this deals with a felony, and that's a fairly serious charge. That the reason why it's limited to written communications is, one, they're a little bit more formal, and two, there's more evidence. as opposed to someone just saying, John Cosgrove came up to me and says, I'm gonna effing kill you. And at the bus stop, and no, there's no witnesses, and no, there's no documentation, but I've just stated enough to get an indictment.
Senator Peterson, you're right, but I wish you wouldn't refer to my wife in that way.
What?
No.
Okay.
She's going to kill me.
All right, fair enough.
Yeah.
Okay, gotcha.
Mr. Chairman, I'd answer the senator, yes, that is correct. There is formal evidence in a written form. However, I think if somebody's in a public place, like a Commissioner of Revenue's office or a DMV office, and makes that type of threat and is heard by numerous people, I think you have a great deal of evidence in that way as well.
Mr. Chair,
Senator Deeds.
I mean, as I read this, if you're 12 years old on the playground and you get in a scuffle and you say, I want to come beat the crap out of you, you're all of a sudden subject to felony liability.
Mr. Chairman,
Kids.
Yeah, Mr. Chairman, I'd say the same holds true. It'd be a Class 1 misdemeanor.
But no, it would be a felony under this
Under this legislation, I'd say
Under this legislation?
right now, it would be Class 1 misdemeanor. So I understand what you're saying.
All right, any further questions of the patron? Anybody to speak in favor of the bill? Yeah, Senator Morrissey.
Just a question. Senator Cosgrove, I think I understand the spirit of this, but would this language, particularly in paragraph A, lines 15 through 19, capture that situation where the husband and wife are in an argument and the person, either spouse says to the other, not intending to kill them, I could kill you or I want to kill you, and it's done in the heat of the moment. Would your bill capture that behavior and make it a felony?
Mr. Chairman, and answering the gentleman, I believe it probably would.
Okay. Any other questions?
Thank you.
Anybody would like to speak in favor of the bill? Anybody like to speak against the bill?
Mr. Chairman, I should note that when staff reviewed this bill, and I think we've reviewed it in the past, we had significant concerns. No disrespect, it's certainly motivated by sincere concerns, but our concern was that it went further than the patron would intend. The problem with oral threats is that sometimes words can be uttered that objectively, if you don't hear them spoken, you don't appreciate that they're being said, for example, in humor or in jest. One might say, I'm going to kick your ass, laughing, but upon admission that they had said those words, then it becomes a different thing. It exposes them to liability that was never intended. It also, the other problem with oral threats is that sometimes they're the product of impulse, especially with kids. A kid might say something that would cause felony liability, not meaning it just because they have troubles with impulse control and they would never follow through with it. And so I know that the patron intends to reach very serious conduct. Our concern was that the bill would have unintended consequences and sweep further than the patron would intend.
Mr. Chairman, I'd answer Mr. Benjamin that he has some salient and valid points. I would also say I can do the same thing in a text. I'm going to kick your ass, LOL, LOL. It carries the same connotation. You can take it one way or the other, you know. Either I'm ha-ha, looking forward to it, or ha-ha, only kidding. So.
Any other discussion? Is there a motion?
Thank you.
Motion to PBI, which is seconded. All in favor of the motion, vote aye. All opposed, no.
Okay. Thank you, Mr. Chairman.
All right.
Ayes 8-6.
8-6, PBI.
Thank you, everybody.
Senator
Appreciate it.
Cosgrove. All right, the next, Senator Reeves. Okay.
Thank you, Mr. Chairman. I've got two bills before the committee this morning. One bill this committee has heard before it came out of the committee.
Which number are we? 197?
No, 467, Mr. Chairman. Went to the House, passed there, and Governor vetoed the bill due to the mandatory sentencing requirements. This is has to do with injuring or maiming a police dog or a service dog in the performance of its duties, either with the National Guard or law enforcement. I have This was brought to me by my Spotsylvania's Commonwealth Attorney Travis Bird, who's here today, as well as Sergeant Kelly from our police department or our sheriff's department, and his dog Dux, who was shot multiple times. And Sergeant Kelly has also received wounds in combat. And Mr. Chairman, what's changed on this bill is rather than do a mandatory minimum, we just are asking at this point that a punishment shall be separate and apart from and shall be made to run consecutively if they are sentenced on a charge of injuring that animal. And they've come all the way from Spotsy and I'd like the committee to be able to hear from them.
Okay. It's already an offense. You just want to make the punishment consecutive.
We won't hurt you, Lana. This is a good job.
Okay.
Good morning.
Don't shoot it.
Go ahead.
Good morning, Mr. Chair. I'm Travis Bird, Commonwealth Attorney, Spotsylvania County. I'm here with Sergeant Kelly and our K-9 Ducks. This comes before, basically Commonwealth feels that this, an attack on our law enforcement officers or our K-9s are assault on the system of justice in and of itself. Not only is there a large financial cost to getting a K-9 up and running, it's approximately $40,000 to the taxpayer to even get a K-9 on the street and on patrol. But they do other things. Not only are they arrest suspects, but they detect bombs, they find missing persons, they find deceased persons, and they even protect this building that we're standing in as we speak. They take large quantities of drugs and illegal weapons off the street, they recover stolen property, and they're actually protect suspects because they're a less than lethal form of use of force. It's an option that law enforcement has to take down a suspect without lethal use of force. In the worst case scenarios, as in Dux's scenario, it takes a bullet for one of our sworn law enforcement officers. The suspect in this case did attempt to kill 2 of our deputies and did in fact shoot Dux in the process. Had Dux not been the closest one to him, that would have been one of our deputies to take the rounds that Dux took. Based upon that, we're asking to simply run time in any charges of this consecutive, make that the law, not concurrent, because these dogs protect not only our citizens, but protect our law enforcement officers, as well as, even if you go to the basic simple fact, it's a large financial expense to replace these well-trained animals. And I will point out that as far as I know, and as far as Sergeant Kelly knows, Dux is about the only K-9 that we know of that was actually able to return to duty after being shot in the line of duty. And he's actually somewhat of a famous K-9 because if you go to the National Law Enforcement Officers Museum in Washington, D.C., you'll see Sergeant Kelly and K-9 Dux's statue there. And that's why they were in fact picked. So we'd ask that the committee support this and pass this bill.
Senator Morsi.
Question for the speaker.
Yes, Senator.
Right now, it is a Class 5 felony to injure that dog by the means set forth in the statute. We agree?
Yes, Senator.
Your language that you're including in there begins on line 17 and says, such punishment shall be separate and apart, et cetera.
Yes, sir.
Why do we need that language in there? Because you could bring an indictment for, say, robbery against an individual, and then say that defendant also harmed the dog. You bring an indictment under this code section. We don't normally have that language in every bill under 18.2. It is, I think it's superfluous. It's given that it's an additional charge. So maybe I'm missing something, and if you could focus on that.
Yes, sir. Yes, Senator, I'll be happy to answer that. Basically, for example, in our situation, for shooting our K-9, the suspect received absolutely 0 active time. He actually only received 1 year for each attempted capital murder. So
Senator Morsi.
I'm sorry, I think I'm going to cut you off. Go ahead. You were saying something.
And I was
right.
Yes, sir.
The time that he got for the attempted capital murder, that's respectfully not part of this discussion. Did you bring an indictment against that individual for a violation of 18.2, 144.1?
Yes, sir.
Did the jury find him not guilty?
No, sir.
Found him guilty?
The court did, yes, sir.
Court found him guilty?
Yes, sir.
All right, but that's the problem with the judge then, who found him guilty and just gave him, I take it, a suspended sentence.
That's correct, sir.
And again, that doesn't capture what you're doing in this language. The judge could have given him, up to Class 5 felony is up to 5 years. So I'm not following it. The judge could have done that. This doesn't correct that. If you had said to me, if this was language in there that is a mandatory 2-year sentence, then that would be a different thing. I'm not sure I would agree with it because I'm not a fan of mandatory minimum sentences. I am a huge fan of dogs, an animal lover. I don't understand that, I don't think this captures and addresses the concern that you had, certainly in that case. That was...
Yes, sir. To answer your question, Senator, in response, of course, we did have a bill that requested mandatory minimum time that did pass both houses and was vetoed. But to fall back, if the Assembly did not see it that way, we want to ensure that a court cannot run time concurrent with a sentence of active sentence actually given for harming one of our police canines, which is essentially a non-sentence if it's run concurrent.
Okay. When it's appropriate, I'll speak to the bill.
Mr. Chairman.
Senator Serval.
Thank you.
Yes, thank you, Senator.
Mr. Chairman, speaking to Senator Morrissey's question, I just noticed that in the code, we use this separate and apart language at least 3 times in other places, so this isn't like treading new ground.
Okay. All right, anybody else want to speak in favor of the bill? Yeah. Wayne?
Mr. Chairman, Wayne Huggins, State Police Association. You may remember that 2 years ago, one of our canine, Vader, was involved. 2 of our troopers were involved in a shootout with a suspect from Connecticut who was wanted for a double murder up there. Our canine was killed in that incident on Interstate 95 down in Sussex. So we very, very much support this bill as well. Thank you.
Okay. Anybody else in favor? You got 31 seconds.
Dana Straub, Virginia Association of Chiefs of Police. We do support this legislation.
Okay.
Lieutenant Gilbert with the Virginia Sheriff's Association. We support the legislation.
Okay. Anybody else? Anybody against the bill? Step up and speak. Okay. Is there, Senator Reeves, wrap it up.
Mr. Chairman, I would just tell you, I think we've tried the road that Senator Morrissey's been trying to go on. The governor wasn't with that. I think this is a good step in the right direction to help these guys take care of their animals. There is a significant cost to training and bringing up one of these canines, and I think this is a reasonable measure, and I'd ask that the bill be looked upon favorably.
Okay. Is there any further discussion? Is there a motion? Is there a motion to report and second? Any discussion? Yes, Senator Morrissey.
Mr. Chairman, to be brief. Senator, again, I am a huge animal lover, and it's so repulsive to think that another human being would injure a dog, any dog, whether it's a canine or another dog, by poison, shooting, etc. I've had a couple of them on my farm where hunters have done just that. It's so offensive. But in this situation, first of all, juries, when they sentence, it's always consecutive, and a judge can determine whether or not it's to be consecutive. The judge can determine whether or not he wants to give 5 years and suspend it. I just don't see this language as necessary, as much as I appreciate the Commonwealth's attorney and the senator bringing this bill. I've got some troubles with it, and for that reason, if it comes to a vote, I'm going to vote no.
Okay. All right. The motion's on the floor to report the bill. I will say that I'm a dog lover, but I think the judge has the authority to do this anyway. All in favor of the motion to report, vote aye. All opposed, vote no.
6, noes, 9.
The vote fails to report by a vote of 6-9. Thank you, Senator Reeves. Do you have anything else?
Mr. Chairman, I have Senate Bill 948.
948.
Mr. Chairman, this is a little bit baffled why this would be in here, not in finance, but maybe it's because it's a contractual agreement. But this bill, 948, would allow the Department of Military Affairs to grant real estate interest up to and including ground leases to governmental and private entities for the provision of unnecessary services and maintenance of compatible use buffer at the State Military Reservation, Camp Pendleton down at the beach. And the reason we have that, Mr. Chairman, that's a critical piece of property for us. You have Dam Neck and the SEALs that use part of the beach for training, for some of their urban warfare. We have some military housing down there, as well as the Red Horse Battalion, which, if you're from the beach, you're very familiar with the Red Horse Battalion because they're the ones that provide a lot of the emergency services and critical state emergencies. This is a very, very important facility. It's 312 acres. I have Colonel Dunn here as well to speak to the bill if anybody has any really questions about it. But this is going to allow the Department of Military Affairs the opportunity to do some public-private partnerships and write some leases, and that's the bill, Mr. Chairman.
Okay, any questions of the patron? Anybody in favor of the bill? You said Colonel, somebody's here?
Colonel Dunn, you want to come up?
Okay, if you.
He's retired now, but I didn't recognize him because he had a beard now, because last time I saw him he was in
The
uniform.
colonel with the beard, retired.
Morning, Chairman.
Go ahead.
Is there a question?
Sure, you have a question?
Yeah,
for
yeah,
the
do you
Colonel?
have any, you promoting, you support the bill?
I'm here to provide technical
Okay.
testimony.
All right. Any questions? Anybody against the bill? Is there a motion? Moved and seconded to report the bill, to go to finance. It's got to go to finance. All in favor of the motion to report and re-refer to finance, vote aye. All opposed, no. Motion carries.
Thank you.
15 to nothing.
Thank you, Mr.
Senator
Chairman.
Reeves.
Thank you.
Yeah, thank you very much. Okay, Senator DeSteph, I believe.
Mr. Chairman, members of the committee, good morning. We have two bills today. The first one's on parental alienation. That's Senate Bill 483. The proposed 483.
483, okay.
The proposed legislation establishes a new Class 6 felony. We do have a budget amendment in at Finance. Offense for any parent, guardian, or other person responsible for child care of the child under the age of 18 whose willful act of omission interferes with the child's contact and relationship with the other parent, guardian, or other person responsible for the care of such child, including unreasonably denying the other parent, guardian, or other person responsibility of care of such child access or visitation with such child. Mr. Chairman, if I may, I've got folks to speak on this, but I'm going to summarize it real quick.
Mr. Chair, if I can understand, if I can ask a question.
Yeah, yes, Senator Dees.
If I'm a custodial parent and I'm under an order, and the other parent, non-custodial parent, has visitation rights, and I deny that parent visitation rights, or I talk badly about that parent, aren't I already subject to contempt of court?
Mr. Chairman, I'm not sure about that. I'd have to check with one of the attorneys, but I do know that there are multiple cases of this throughout the Commonwealth, and we put in the bill for one of our folks who are here to testify today. We've been approached by over 100 other individuals on this situation. And there's been a lot, and every single individual I talk to has the same thing. They've run up tens or hundreds of thousands of dollars in legal fees to defend themselves and get access back to the child. With that, I'd like to have our first individual who's going to testify on this, Mr. Chairman.
Okay.
Thank you. My name is Darla Grease, and this is my son, Brady Grease. Thank you for having us here, and thank you, Senator DeSteph, for making this possible. In order to protect my son's privacy today, I'll only skim the surface of explaining the details of our situation, which is thankfully now over. The scars, however, still remain. I did prepare a more detailed statement, though, and I do have copies to leave with you today. When my son was 8 years old, an individual that I once had a long-term relationship with began to alienate him from me. My son's behavior towards me began to change, and changed drastically. He began telling me that he hated me and that he never loved me. He started using language that 8-year-olds wouldn't use, acting out in school, and developing physical ailments. He confessed that he had no recall of any good memories between he and I. I have months' worth of medical records that support these things and more. I learned that this process of manipulating children is called parental alienation. Until experiencing it firsthand, I had never heard of such a thing, It destroys the crucial parent-child relationship, and sometimes that relationship never recovers. Kids grow into adults hating one of their parents because of another adult's anger or resentment. Some of these kids are being coached to say terrible things. Fathers are coaching their kids to say mommy uses drugs. Mothers are coaching kids to say that their dads are doing inappropriate things to them. One parent is made to look terrible while the other looks like the hero. It's a very cruel and systematic act that needs to be understood, recognized, and stopped. Shortly before I left that relationship, I discovered that my son's alienator was secretly recording me on an iPhone. His alienator began prompting severe arguments between us by speaking poorly of my deceased twin sister and my family members. Those arguments would soon become ammunition to seek custody of my son. It was a very deliberate, well thought out, and methodical plan, and a plan that for a while was successful and wreaked havoc on my relationship with my son. My angry ex sued for custody of my son, and before I knew it, I was fighting to keep my own child. As litigation persisted, so did his hatred towards me, and it was devastating. I didn't know why he was saying the things that he was saying, and for the life of me, I couldn't understand where his hatred was coming from. It was deep-rooted and broke my heart in a way that I can't even know how to express. During the initial court proceedings, the judge and guardian ad litem didn't believe my concerns of alienation. They instead sided with my son's alienator and gave the abuse a green light. That abuse continued for months that seemed like years. I was mocked and scolded time and time over, both inside the courtroom and in reports. I was sentenced to serve jail time, which thankfully a circuit court judge overturned. All along, I was still trying to convince my son that he was safe to be with me and free to start loving me again. By the grace of God, as my son grew older, he began explaining to a therapist and to the guardian ad litem how he was manipulated, and finally the truth was revealed. The recordings that portrayed me in an unfavorable light were being played for him. He was being told that I did illegal things. He explained that he was being coached to say certain things. By the time litigation ended, I had paid my attorney over $110,000, and I still owe him over $105,000. A 2-year litigation period has destroyed our financial future. Brady's college, my retirement, every single aspect of it. To say that our lives have been changed forever is a profound understatement. We'll struggle now for the rest of our lives because of one person's cruel attempt at taking the person that matters the most to me, my child. It's my opinion that trying to destroy a patient's relationship with their child is nothing short of heinous and should be punishable by law both civilly and criminally. Sadly, this is happening across the country, and I hope that today our great Commonwealth takes the lead in educating our judges and guardian ad litems on how to recognize what's real and what's being fabricated, because time is of the essence. Young children who are being coached are not going to say that they're being coached. It's brainwashing them to believe that a reality doesn't exist. I can't tell you how many nights I spent on my knees praying to God for answers as to why we were going through such a nightmare. But today, as we stand in front of you, that question is finally answered. Thank you for listening, and thank you for welcoming both Brady and me here today. It's a day that we'll never forget.
Thank you, ma'am. Okay, are there other speakers? We're way over time, so just briefly state who you are and what your position is on the bill. And
My name is Zachariah Hoffer. I'm a voice for my daughter Angelica and for hundreds and if not thousands of parents and children in the same situation. I'm going to make this brief, but my story is very intense. My daughter, her life was taken as a result of parental alienation. It doesn't get much more serious than that. We not only do we have a right to our children, but our children have a right to us. This has been established in every authority of the land, and there is no remedy that's realistic. You mentioned contempt. That is not realistic. That does not happen. That is technically on the books. It does not
it
happen.
happens all the time in the courts where I practice.
Yeah, on maybe the third or fourth time that it happens, and this is not realistic. It is not a realistic remedy. I know hundreds, if not thousands, of parents that I advocate with that have expressed the same thing. I'm just going to touch on a couple things here that I feel like you need to know.
As I said, we're way over time.
I know,
so
I understand
please
that.
be brief.
Please. My daughter's life was very important, and I'm on my way to another hearing in the murder trial for my daughter right now.
after this. So if I could just borrow your time for just a second. This is, like I said, she expressed it very well, so I'm not going to go into the details of that. This is child abuse and it is domestic violence. The man who was allowed to be around my children during this alienation had a severe criminal record, including rape, kidnapping, assaults, robberies, burglaries, and much more, and was allowed to be around my children. Family court did not do anything about the denial of contact. I had 50-50 custody of all 3 of my girls at this time, and I had that for 5 years prior to him moving in, prior to the alienation. Alienation is an insidious practice, and it recruits dangerous people into the practice, and this needs to stop because the remedy is not working. It needs to be a crime because it is child abuse and it is domestic violence. Thank you. And it cost me, it cost my child's life. And I want you to remember that. Her name is Angelica Marie Hoffer. Thank you.
Okay. All right, next. 404 minutes, 12 seconds.
Hi, I'm Kim Ramsey with the Family Law Coalition, and we do oppose this bill. As stated by some of the senators, we believe that there is already legislation that covers this, and these are terrible, terrible cases. We don't deny that, but they are a case-by-case basis where perhaps there was not a good outcome in the case, but we don't think the legislation needs to be changed.
Okay.
Good morning, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We oppose this bill.
Good morning, Mr. Chair and members of the committee. Valerie LaRue from Virginia Poverty Law Center. We also support this bill. It would have a deleterious effect on families where domestic violence is involved in the custody dispute. And Senator Deeds is exactly right as far as the contempt. I think we've all seen that. Thank you.
Okay.
I'm sorry. We oppose the bill. I'm sorry.
Okay.
I'm sorry.
Anybody else opposing the bill? Yeah, coming up.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and I'm not unsympathetic. I've gone through this particular situation myself, but this bill is so much broader than the examples that have been brought up. This is any interference, not even court-ordered visitation. This is any interference with visitation. I went through it and survived it fine. I mean, you know, it was a situation where my ex was saying, you know, Dad wants to put me in jail, and I didn't. I did not go through the contempt process. This is now going to be Dad wants to put me in prison. This is going to weaponize every single contentious divorce and every past divorce where the children are under the age of 18, and for that reason, we oppose this bill.
Okay. Anybody else like to speak? I want to wrap it up, Senator DeSteph?
Mr. Chair. Oh, I'm sorry.
Yes. Where is that? Senator Peterson?
Well, I don't know if the sponsor had a last word or.
No?
I think that when parental alienation costs our children's lives, that we need to take a hard stand on it. And I think we truly do need to do something to make a difference.
Okay, is there a
Mr.
motion?
Chair, I have a motion.
Okay, go ahead.
I'm going to move to PBI the bill, and I respect the patron. I thank his witnesses for coming to testify about their own personal circumstances. I have a concern about criminalizing our domestic relations laws, which are already emotional enough, and especially concerned about trying to solve every social problem with a Class 6 felony for people that we think are acting badly. I recognize the current system does have flaws. It's not perfect, but charging people with Class 6 felonies for what are now rules to show cause is not the solution. So I move to PBI.
It's been moved and seconded to PBI the bill. Any discussion? All in favor of the motion, vote aye. All opposed, no.
Mr. Chairman, members of the committee, thank you very much. We also have
The bill's been PBI 15-0. Okay. That PBI, by the way, means passed by indefinitely, in case anybody didn't understand. Okay.
Senate Bill 42, which this is aggravated sexual battery. You've heard this already once by Roos.
I think.
Mr. Chair, that's not on the docket. My understanding is the subcommittee reports will be Wednesday.
Yeah, you want to have somebody speak.
We did. We had somebody speak before. They actually came up with the understanding it was going to be heard today. So I was going to, if it's okay,
Go
Mr.
ahead,
Chairman.
yes,
just
that's right, go ahead.
For a couple of minutes on your time.
This was heard at the Criminal Law Subcommittee, and the report will be Wednesday, but go ahead, speak. You have somebody who wants to speak.
Thank you, Mr. Chairman.
Senate Bill 42.
Thank you for making the time for me. Good morning, my name is Amanda Condon. I've been a police officer with the Virginia Beach Police Department for 11 years. I spent 3.5 of those years in the Special Victims Unit investigating sexual assault against children and adults. I participated in many different training courses on trauma-informed investigations and have years of experience with victims of trauma. I've learned that when it comes to traumatic experiences, it's no longer just a fight or flight response. It's been discovered that there is a freeze element involved. Through my experience, I've recognized an issue that several other detectives and I have run into. On several occasions, we've come into contact with victims that were sexually assaulted in situations where they trusted a professional with their body. Whether it was a massage therapist, a chiropractor, a holistic doctor, etc., these individuals trusted the professionals with their body and they were violated. A particular case that I investigated involved a female who went for a massage for the first time ever, and the massage therapist penetrated her vagina with his fingers. She froze in the face of this violation, as many others do, trying to process what was happening to her and frightened of what else he would do. The basis of this crime, the vaginal penetration, should fall under the felony code of object sexual penetration. Unfortunately, that code requires force, threat, or intimidation to be a factor, which oftentimes is not present in sexual assault, especially under these circumstances. When we come across these situations as detectives, we are urged by our prosecutors to charge with misdemeanor sexual battery, as that allows for force, threat, intimidation, or ruse. The element of ruse has allowed us to charge those that earn the trust of their victims as professionals, but only with a misdemeanor. Ultimately, these victims that had a felony-level assault committed against them were being told a misdemeanor charge was being filed, and either didn't see it was worth the pain of testifying or didn't feel the punishment would be worth the effort. The punishment should match the crime. I am here in support of SB 42 so that individuals who are preyed upon in this manner are able to get the justice they deserve. I also hope the law continues to evolve to stay aligned with discoveries in trauma and its effects on people. Thank you for your time.
Okay, thank you very much. I believe we heard this in Criminal Law Sub on Friday, I believe. And
Mr. Chairman, that's correct.
Thursday.
We've heard it in full committee once.
Yeah.
It went there for rewrite. We worked with Mr. Benjamin and staff attorneys for the complete rewrite of this to break it down into the two areas. We've done that. I think we've made everything exactly how we wanted.
And Mr. Chair, I think we'll have a bill on Wednesday to report.
Perfect. Thank you, Mr. Chairman.
Yeah, thank you very much.
See you Wednesday.
I'd like to, is there a motion that at the request of Senator Hashmi, that Senate Bill 408 go by for the day? All in favor say aye. Aye. All opposed no. Motion carries. We also have Senator, let's see, who's next? Senator Hanger, is that right? No. Who's next? Let's see here.
I have Senator Sproul's bill I can present.
Okay, Senator Sproul's bill, that's right. Senator Servo will present Senator Sproul's bill, Senate Bill 955.
Can I do it from right here, Mr. Chairman?
955, yes, go ahead.
Okay, thank you, Mr. Chairman. Senator Sproul explained to me this bill just increases the fee that a marriage celebrant can charge from $50 to $75. Senator Sproul tells me this fee hasn't been increased in over 15 years and that a lot more people are getting divorced by celebrant instead of by minister, and that the celebrants would like this fee increase. That's what he asked me to present.
And a motion's been made to increase the fee from $50 to $75 for a marriage celebrant. Correct? And motion's been made and seconded. Any discussion? All in favor of the motion to report Senate Bill 955, vote aye. All opposed, vote no. Increasing fees from $50 to $75. By ayes 9, no 6, the bill is reported. Okay. Now, who's next?
Increase fees.
Senator Hanger's not here, okay.
Yeah.
Senator Stewart?
By $25.
Huh? Yeah, so Senator Stewart has Senate Bill 144. Protective orders.
Thank you, Mr. Chairman, members of the committee.
Actually got two protective order bills, but Senate Bill 144, it allows the court to issue a protective order upon conviction of several felony offenses including violating a protective order, homicide, kidnapping, assaults and bodily wounding, extortion, etc. And it allows the protective order to be issued for more than 2 years. And I know some folks object to that. But this situation actually arose out of Stafford County where there's really serious situation between a husband and a wife. And I think she has had to go back now 4 or 5 times to extend this protective order because it only is allowed to go for 2 years. And so what it does is it allows the judge to give you more flexibility in issuing these protective orders in the cases where they should be issued for longer than 2 years. That's the bill.
Okay. Any questions? Mr. Chair, I'd move an amendment on line 142 for period of time. I would insert the word reasonable.
Okay, is there a second? I'll second that. Okay, all right. Any discussion? All in favor of the motion to add the word reasonable before the time, the words period of time on line 142? All in favor of the motion say aye. Aye. Opposed, no. Motion carries. Any discussion?
Mr. Chairman.
Yeah, Senator Serval.
Thank you. I have a question for the patron. So, the gentleman, I assume, Senator would agree that a court could, as a condition of a suspended sentence, prohibit any contact, and does the
Absolutely,
Senator
Mr.
believe
Chair.
that for some reason a protective order presents a better remedy than a sentencing, probation and condition, suspended sentence?
Mr. Chairman, I agree with Senator Serval, except in some cases you run out of that ability and you still have a very hostile situation with no suspended time hanging over the individual. And I mean, let's face it, we're talking about very largely women that are threatened by abusive men. And I saw it as a prosecutor. It was the most difficult thing that I had to deal with as a prosecutor because most of the time they're so intimidated they won't even testify. They're afraid to testify because they're afraid they're going to make the situation worse and the guy's going to kill her. And so, yes, you are right to a certain extent, but you lose that ability at some point, and this would give you that ability beyond where you don't have a suspended sentence or something else to hang over the individual's head for no contact. Is there any other discussion?
Mr. Chairman, one other question.
Senator Serval.
I was curious if the senator has thought possibly about having maybe a longer time period for some of these instead of just having a permanent protective order forever. Maybe making it like once every 5 years instead of once every 2 in these situations or something.
Mr. Chairman, I like Senator Serval. I'm very leery of protective orders, and I've seen the abuse of them. And it concerns me, and I thought long and hard about bringing this bill, but I truly believe it's necessary because there are some folks in our population who need this protection, and I think we have to be diligent in making sure we put good judges on the bench that don't abuse this. That would be my response to that. Any further? Yes, Senator Morrissey.
Question for the patron. First of all, we all agree that the judge at sentencing can add conditions to wit. You are to have no contact with this victim for the rest of your life or whatever. We're in agreement, right?
I'm not sure that you can do that forever. I've seen terms of, I've never seen a judge issue, you may never have contact again. Perhaps you're right.
Normally it would be, you can have say the person goes to prison. When you get out, the judge will say you're going to be on supervised probation for X period of time. Certainly, not only the judge, but the probation officer can say you're to have no contact with the victim.
Absolutely, I agree.
During that period.
I agree. It's just when that part is finished, I don't think the court has any control. That's what I understand, but I may not be correct.
This is my concern, and maybe you can assuage it, maybe you can't.
Is that right?
Right now, I realize there is a burden on the victim to come back to extend it. But that also provides the opportunity for the court to hear whether or not circumstances have changed. I am worried that this legislation would throw the baby out with the bathwater by having, at the very beginning of the process, a protective order that goes on, could be up to lifetime, when the circumstances may in fact change and when in fact a judge may not extend it. That's my concern, number one. And number two, Mr. Chairman, I don't think we took up we voted on the reasonable inserted in line 142. I think one of my colleagues made an amendment to put in any reasonable on line
Yeah, we did.
142.
Yeah, I did.
We did vote it?
We did. Yeah, reasonable is in
Mr.
line
Chairman.
142.
Okay.
Mr. Chairman,
Mr. Chairman.
First of all, he needs to assuage my concern.
I thought you were done.
Mr. Chairman, if I may respond to Senator Morrissey, I agree with you largely, but what I would say is this shifts the burden. And so now we have, and I hate to keep using women as the example, but it's what I'm familiar with in my practice. Women who are really afraid of these folks, they've got to come in and testify to continue getting the protection of the protective order. If a judge issued one for 10 years or even for life, I still believe that the person subject to the protective order, the respondent, right? The person who's the subject of it could petition the court to limit it. Yeah. So they could now come into court. I think they have that ability anyway, to come into court and say, Judge, circumstances have changed and we don't need this protective order anymore. And in fact, sometimes the other side might agree to that if things have gone on and they don't have to go through this. I think that is a reasonable or a realistic way that this could proceed. I get it. It worries me too, but there are situations where we need this, and when the woman is forced to come in before every 2 years to do this, it's just hard on her, and I'm not sure it helps the situation because you've got to have that testimony over and over again.
Okay, any other questions? Anybody want to speak in favor of the bill? Got a group here.
Mr. Chairman, I have one more question to patron.
All right, Senator Sorrell.
Thank you.
Sorry, he likes to ask a lot of questions.
Sorry, I was a little bit concerned because I thought these weren't modifiable, but now I'm looking down at, I guess, lines 182 to 86, and I see that either party can file a motion to modify. But is there some reason you limited the respondent's ability to modify until all terms of sentencing and probation are completed? Because, I mean, I've seen some judges in some jurisdictions put people on probation for like ever. And, that could limit the court's discretion to modify a protective order.
Mr. Chairman, I don't have any objection to having reciprocal ability to modify. I don't think that's unreasonable if that is your concern.
Yeah.
I think they should have that in the event that everything calms down and they want to do that.
All right, I'll work on an amendment.
Okay. All right, speaking in favor of the bill, Senate Bill 144.
Good morning. Thank you, Mr. Chairman and members of the committee. My name is Jerry Greenspan. I'm a pro bono attorney with Hunt & Andrews Kurth in Charlottesville. My practice for the last 10 years has been exclusively representing survivors of domestic and sexual violence. And I have worked with Stafford County Commonwealth Attorney Eric Olson. And thank you very much, Senator Stewart, for bringing this bill. This is something that would have benefited countless numbers of my clients over the years, and I can give a couple of specific examples. I had a client who was kidnapped by her child's father at gunpoint, taken and held for 3 days, sexually assaulted. Then there was a standoff with the police. He was arrested, sentenced to 17 years in prison. She found out he was getting out. And what did she have to do? Go to court and file for a protective order to protect her against him. She had a new family at that point, and wanted to make sure that there was no way that he could contact her, her children, her husband, anybody. So she had to go to court and face him after 17 years. The first time she saw him was in court trying to get a protective order. She was terrified. She was re-traumatized. She had to go through the whole ordeal over again. That wouldn't have happened if this protective order had been available. He was under a no contact order from his sentence, but sometimes that slips through the cracks. I had another case where my client had been raped by an acquaintance. He was convicted, sentenced to 5 years in prison. he was getting out, she realized, I don't have that no contact order in his sentence. She had to file for a protective order and go through that rigmarole all over again as well, testifying about the rape in order to get a protective order. So this, in addition to sometimes, the no contact order gets missed, it slips through the cracks. The real impact of a protective order is enforceability. A protective order is immediately enforceable by the victim. In a no contact order as part of a suspended sentence, you have to take that back to the Commonwealth's attorney, wait for them to file a show cause, go through a revocation hearing, see what the judge is going to do in terms of reimposing suspended time. With a protective order, you call 911, you go to the magistrate and get a warrant, and the person is arrested immediately. Secondly, this protective order would be issued upon sentencing, and so the court would have the full facts of the incident in front of it, know the full situation, hear a victim impact statement, hear any mitigating evidence, and at that point would be able to make a well-informed decision about what length of time for a protective order is appropriate in that particular case.
Okay, thank you.
Thank you very much.
22 seconds. Go ahead, speak.
Good morning, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. For all the reasons stated, we support the bill. We certainly believe, like Senator Stewart mentioned, that this shifts the burden from the victim and appreciate the ability of both the respondent and the petitioner to be able to have the ability to modify and dissolve the order as needed.
Okay, time's expired. Would you state your name?
Sushila Varkey, Virginia Poverty Law Center. Senator Stewart has brought this bill before. It's passed this committee. It got stopped up in finance, so I hope that you will support it.
Bill's got to go to finance. Is any other?
Mr. Chairman.
Senator Sherrill.
Sorry, I have an amendment now. On line 181, I would like to strike the victim and change that to any party, and then strike the entire second sentence starting on line 182.
All right, read it, read the...
So basically it would say any party made any time file a written motion, blah, blah, blah. And then the next sentence becomes unnecessary after that. And then it picks up with the party filing the motion to dissolve or modify should provide notice, et cetera.
So delete, all right, you changed the line F, line 181. It would read, any party may at any time file a written motion with the court requesting a hearing to dissolve or modify the order, period, and delete the remainder of line 182 through line 186. Is that right?
No, you would leave the last sentence.
All right, delete the next sentence, which is remainder of line 182. I'll read it. The defendant may file a written motion with the court requesting a hearing to dissolve or modify the order upon completion of all terms of sentencing and probation imposed upon the conviction for the offense authorizing the issuance of a protective order. Delete that, correct?
Correct.
Okay. And it's been moved and Senator
I
Stewart.
don't have any objection, Mr. Chairman. to
Moved
that.
and
I
second.
think
All in
that's
favor of the
probably
line
implicit in the
amendments,
court
say aye.
anyway.
Aye. All opposed, no. Okay. Is there a motion to? It's been moved and seconded that the, I guess, substitute be reported and re-referred to finance. All in favor of the motion, say aye. Aye. All opposed, no. Vote aye. Vote. Okay. Clerk?
15-0.
The substitute has been reported and re-referred by a vote of 15-0. Thank you, Senator Short.
I hope it does that well in finance.
That was a problem last year, wasn't
Mr.
it?
Chairman, you want me to keep on going?
Yeah, keep going, huh?
Senate Bill 145, and what this does is it enhances the penalty for violating a protective order in certain cases to a Class 6 felony. Policy decision, Mr. Chairman, and someone did mention to me, in fact, that on line 32, where it says bodily wounding, we should probably have bodily injury. I don't know what the committee's feeling is about that. It lessens the standard to injury from wounding.
Okay,
I'll second it then.
line 32 and line 59,
To strike wounding and put injury.
change bodily wounding to bodily injury.
Yes, sir.
On lines 32 and line 59. All in favor, it's been moved and seconded that motion be approved. All in favor of the motion, say aye. All opposed, no. Motion carries.
I don't know if there's anybody here to speak to this or not, Mr. Chairman, but again, it's just a policy decision on the committee's part.
Mr. Chairman.
Senator Sherwood.
Thank you, Mr. Chairman. A question for the patron. So, I mean, I appreciate what you're trying to do, but this gives me concern for a couple reasons. I mean, first of all, you know, these protective orders that this covers can be issued, they're obviously issued ex parte, and this would apply to a protective order before it's actually been litigated. So in the 2-week period before it's actually been heard. And if you add just a regular old assault, not an assault and battery or wounding, but a regular old assault, that's like purely verbal. That's like if you basically try and scare somebody. And, you know, that obviously there's all kinds of proof issues with that, but if you subject somebody to possible felony prosecution, that results in a lot of people cutting deals when they shouldn't because they're facing a felony conviction based on just one person's saying something happened. And when you elevate something that's purely verbal to a felony, to me, that it jacks up the consequences so high that it creates bad results and real imbalance. It just gives me a lot of pause. And I don't know if that's one of the things I'm thinking about in considering this. Maybe you could address that. I don't.
Mr. Chairman, the gentleman, I think, is largely correct. An assault is putting someone in reasonable apprehension of bodily harm, and I think that could be with severe words. Certainly, it could be that. But again, the issue here we have is, and maybe I've seen more of these than other folks have, but you've got a situation where these things can escalate so quickly that a woman can lose her life. And I think we need to be clearly send a message that if a protective order is issued against you, we take it very seriously, and you better leave that woman alone. And that's all I can say. I can't debate. The gentleman is largely correct in what he said, and I can't debate that.
How does your bill change the existing law, which is?
It makes it more severe in certain instances, and I may have to ask for Charles or Kristen to help me with the specifics because I don't have them right at
Especially
hand.
it says resulting in bodily injury. Yeah, Charles?
Mr. Chair, current language, current law provides that the assault and battery has to result in a bodily injury. So this changes it so that it's, as Senator Sherwood said, any assault or even any offensive touching that may not result in bodily injury would be covered.
And so, Mr. Chair, I want to understand, you know, I helped the patron amend this language, bodily injury. What does that add to assault and battery?
A bruise. It's a bruise or
But-
strangulation. It goes beyond battery, I think. Because battery can just be, I touched you, and you didn't want it.
But you're guilty of assault and battery if you cause bodily injury, aren't you?
It would be a lesser included offense of bodily injury, right?
Is there an offense of bodily injury?
Mr. Chairman?
I'll ask for help.
Yeah, Senator Morrissey.
Let me just try to address that. The assault is simply a threat. You put your hand back.
Could be.
The assault and battery, the battery portion is an unwanted touching, all right? That was an unwanted touching that I just did, but it didn't commit an injury. And then you can see the gradations after that. So Senator Serville's concern was assault. That could be the pulling the arm back.
Apprehension, reasonable
Correct.
apprehension.
The assault and battery is the touching that I did to Senator Boysko. I just touch her, or you point somebody and point them in the chest. And the wounding, the bodily wounding is what you said, or bodily injury. That could simply be a bruise. So those are the.
But that's still an assault, that's my point.
Oh, yes.
I think you're right.
Every one of those is an
Assault,
assault.
Mr. Chair, and I believe
Senator, Charles?
The question was, what does the amendment to bodily injury do? That just picks up the reference in the rest of Article 4, which are more severe offenses, so like malicious woundings. So that just is making it sure that that's covered as well as assault and battery or assault, simple assault.
Well, to their point, Mr. Chairman, is that necessary?
It could be superfluous because assault and battery is a lesser included of those other offenses.
And maybe you're just comfortable with a battery and above. I don't know what the committee's comfortable with, or you may not be comfortable with the bill at all, but.
As I understand it, it really doesn't change anything other than an assault and battery without a bodily injury.
Wounding.
Under a protective order means it's a felony.
Mr. Chairman, I think currently it has to be a wounding, is that correct? So
it's got to be bodily injury.
It's got to be bodily injury.
To be a felony under a protective order. This would make it a felony whether there's bodily injury or not. That's the difference.
Okay.
Okay, someone speak in favor of it? Okay. You got a spokesperson here, Senator.
Sushila Varkey from Virginia Poverty Law Center. I think the point is that when there are protective orders, we know that those are oftentimes for escalated violence. It's a more dangerous time, even when it is ex parte. So I think that's the point, that if someone is willing to violate that protective order after it's been issued, this is a more dangerous time, and I think that's what Senator Stewart was trying to do in saying, and I'm open to removing assault on its own, but assault and battery or bodily injury would lead to a Class 6 felony.
Mr. Chairman.
Would you like to remove the assault? Yes, Senator Sherrill.
I'm sorry, but I even have a problem with assault and battery, just because, an assault and battery can occur and not leave any evidence whatsoever of the assault. And so, of the assault and battery. I mean, chap just assaulted and battered me. I mean.
But you don't have a protective order against him, and there's not all of the conditions
True.
and dynamics, et cetera, that would have existed.
I don't, but you could make out a case, you could start a case over this, over somebody's verbal allegation that somebody assaulted and battered them. And there's no corroboration. And as soon as you felonize something, it creates tremendous pressure on somebody to plead guilty and compromise and not go to trial. It puts it in a whole different category of cases. And I'm comfortable with the wounding piece because there's a wound, there's a cut, there's like a serious injury, and you can see that. But when it's just verbal stuff, and I've seen these protective orders abused. I've seen one's issued that should never been issued. Then I've seen petitioner sort of bait somebody into having a conversation or come see me or something, and then the conversation doesn't go well and it becomes a big mess. And I just worry about where these things go and the pressure it creates.
Well, Senator Sherrill suggests you just vote against it because right now you have to have resulting in bodily injury. And with the new bill, the way it's designed, you don't need to have bodily injury, just an assault and battery or an assault.
Well, I've seen.
A question for the
Senator Morrison.
witness. I'm sorry, ma'am, what's your last name?
Varkey.
Ms. Farkey, I knew that, but I forgot. Ms. Farkey, you realize that this language under, beginning in line 32, also covers that initial 72-hour emergency protective order.
I do understand that.
So here's my concern, and that an individual gets a protective order, it's ex parte. We all had a long discussion in the chamber about ex parte and not having due process in another bill, Senator. Gets an emergency protective order, it's good for 72 hours. During that period, and it could be as they're walking into court to address the protective order, emergency protective order, points his finger, says, something untoward. It captures that conduct and makes it a felony. That's troubling. I would find this bill much more palatable if it struck the language on line 32.
About 10 minutes, I gotta make a phone.
And it struck the language, any assault and battery, comma, or, and put the word and in front of it. And also on line 33, put permanent in front of protective order.
Yeah, I would not I wouldn't support that.
Okay.
What I want to
Senator?
say, Senator Morrissey, is under a lot of circumstances, many circumstances, I would say most, when a person's getting an emergency protective order, that is not the first time that there's been an act of violence, force, or threat that could result in bodily injury, et cetera, right? We're talking about a pattern. So at the point, whether it's an emergency, a preliminary, and I do hear where you're coming from, or a 2-year protective order, if this person violates it, I like Senator Stewart's language of an assault and battery or bodily injury, it should be a higher level penalty. Thank you.
Do you want the word assault in there? That's the question.
I think what we're saying is we recognize that assault could be removed from it.
Is there a motion then?
But you still want to be assault and battery and bodily
A
injury.
motion that's been made and seconded to remove the word assault. So
Assault, comma.
line 32.
I don't know where it all needs to go, but
32 and 59.
I mean, I understand an assault, to Senator Morrissey's point, is reasonable apprehension before you actually do anything.
So if you change it, delete the word assault, it'd say, on line 32, if the respondent commits any assault and battery or bodily injury in violation of such and such, it's a class 6 felony.
Correct.
Is that right? Okay, so
Yes, Mr.
moved
Chairman.
and seconded on that. All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries. House law votes aye too.
One more amendment, Mr. Chair. Senator Stewart, on line 33, given your and my conversations, private conversations regarding the horrors of ex parte matters, would you consider it a friendly amendment to put in front of, on line 33, protective order, the word permanent? Being mindful that somebody can get an emergency protective order ex parte.
Mr. Chairman, if I may respond to Senator Morrissey, I actually think it's more critical during the early stages because that's the most volatile time. As what I always saw as a prosecutor, and I'm sure you saw the same thing, was when this first happened and you're trying to get the woman to come in and testify and they just won't. They're afraid and you don't want to charge them with obstruction of justice or something like that. So I actually think I don't support that. And maybe I'm in the minority, but I think that's the most volatile time that you probably need the heightened penalty is during that early stage, quite frankly.
Is there a motion?
I'm going to withdraw the motion, Mr. Chair, since the patron didn't accept it.
This
Mr. Chairman.
motion to report the substitute.
Mr. Chairman, if I do have a question for the patron, I think, and this is just wordsmithing, I don't know that it's correct to say commits a bodily injury as opposed to commits a violation of Article 4 resulting in bodily injury. Isn't that a more accurate way of putting it, would be my question? Commit a violation, not commit a bodily injury. We don't think of people committing that they cause or they do something, they commit an act that results in
How about
bodily
changing the word or to causing?
I have no objection to that. I don't know
And
that it's-
causes, or causes. Put the word or causes, add the word causes before
Mr. Chairman,
bodily
that would be better.
All right, the motion's been made to add the word or, the word causes between or and bodily injury. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Is there a motion to report the now substitute and refer to finance? The motion's been made to report and refer the substitute to finance. All in favor of the motion, say aye, vote aye. All opposed, vote no.
Why not have to go to finance?
7 noes, 8.
Spent a lot of time on
7
that.
to 8.
Thank you, Mr. Chairman, members of
Sorry,
the committee.
Senator.
That's okay. I have Senate Bill 331 next. Very simply, Mr. Chairman, and I use mass shooting at a school as an example. Under the capital murder statute now, you can be eligible for the death penalty, or you can also be eligible for life, but portions of that life sentence can be suspended. And what this bill would say is under capital punishment, you could not be eligible for a suspended sentence if you get life, if you have committed a premeditated murder in a school setting. And you know I brought this bill. We're faced with these school shootings and mass shootings in K through 12, in the universities. And that's what it's intended to cover, trying to get at that as best we can. I filed other bills along this vein that also go towards mental health treatment. I don't think they'll come through here, but that's what the bill is supposed to do. It's what I want it to do.
And Mr. Chairman, we do have
Steve?
a technical amendment to better effect the patron's intent. Looking at lines 56 and 57, we understand that the patron wishes this to reach the killing of a person who is on the school property. And if that is correct, then we would delete the language on line 56 of any person by another when such person is upon, and we would replace that with the following language. By another of any person lawfully on.
So if somebody's unlawfully, you can kill them?
That's line 56 and 57. We would replace the current clause that we're replacing is of any person by another when such person is upon. We are replacing that with the following language so that it would read, the entire sentence would read, the willful, deliberate, and premeditated killing by another of any person lawfully on the property, etc.
So, Steve, so in other words, if somebody's not lawfully on the property, it wouldn't apply to them, the victim?
Well, I think we're trying to reach students and teachers, and they
Students
are
and
certainly
teachers.
lawfully on the property.
All right, okay.
I question that myself, but I guess it wouldn't go to, I mean, that's reaches everybody we're after, and that's trying to protect the teachers and the students and the people who are there. If there were another gunman, to Mr. Benjamin's point, he would be there unlawfully. If that gunman was killed by the assassin, I don't know that we want to prosecute him under this for that.
Correct.
I don't have any objection to that, but it's up to the committee.
Senator Boyska.
Right.
Mr. Chairman, I just have a clarifying question. Haven't we seen in some of these mass shootings where there were people who were outside of the school who made their way in who did not have a lawful
Well, that's
reason to
true.
be there? I mean, I'm thinking of Sandy Hook. That was a
That's
teacher
true.
or a counselor's son who showed up out of nowhere, right?
This bill, as amended, would cover any person, whether they're lawfully there or not, who kills another person on that property.
Mr. Chair. Senator Morsi.
Okay.
I think you.
First of all, when Senator Stewart and Mr. Benjamin and I were much younger and had fewer gray hairs, or more hair.
I have no gray hair.
We had 6 items. You all remember this. And every year we've added onto that Christmas tree. Now we're up to, this would be 16. The first thing that I want to point out is that we already have underlined item 7, if it's a killing more than one individual. This Christmas tree now is adding killing somebody on school grounds. Let me tell you who it would cover. If there was a meeting between 2 people, they were meeting at night, they were at the playground, and one person kills the other in what I will call a pedestrian murder, and I'm not being cheeky, but just a regular murder, that would now add that killing to those offenses that would subject that person to death. I don't think that's what you wanted to do. So I can't agree with item 16 as it's written there now.
Mr. Chairman, does that get at Mr. Benjamin's amendment? Because those people will actually not be there lawfully at night, would they, on school premises?
It depends on the facts. If they're trespassing, if they're there after school hours, then they're not lawfully on the property. If the school grounds are open after hours and they meet there, then they are lawfully there. If you wanted to tweak this further, you would say during school hours or while school is in session. but I'm just saying that's if you wanted to.
Mr. Chairman.
Yes, Senator Shortville.
Thank you, Mr. Chairman. So speaking of the bill, first of all, if you look at the physical impact statement that was provided by the Sentencing Commission, they say that in, where is it? 337 sentencing events, there are 2 cases since 1999 that this might have affected.
That's right.
And I don't know what those cases were, but it strikes me that a couple things. Number one is that this doesn't happen very often, number one. And number two, at least to my knowledge, most people that want to go and kill somebody really don't care what the law is or pay much attention to it. And so, you know, this really, what this says is a mandatory minimum life in jail for somebody that kills somebody at school. And, you know, I just think mandatory minimums don't work very well. And I mean, I get what you're trying to get at.
It's capital murder. It's a capital murder.
And Mr. Chairman,
I get it.
he's right. That's my bill. My bill is you don't get a suspended life sentence under capital murder if you commit a mass shooting of children in a school setting. It's just that simple. And again, it's a policy decision, but I think it's important. We've all been struggling to come up with ways to try to thwart these efforts of these mass shooters in school. This is just one more tool in the toolbox, but certainly
Senator, this is not a mass shoot, just any person.
It is,
one person.
yes, but we don't need shootings in schools, because if you fire one round with all those children around, there's no telling how many people you're going to hit. So I refer to it that it really is just that simple. We want to send a strong message about shooting kids in schools.
Senator, on line 34, the willful, deliberate, and premeditated killing of more than one person within a 3-year period. You kill 2 people at the same time, you're subject to the death penalty. We passed that back in 1997. I remember working on it.
I put the original multiple murders bill on.
Yeah, Senator Saslaw.
It's up to the committee, Mr. Chairman.
Okay.
In the case, just the 2 that come to mind quickly, Sandy Hook and Parkland. I think in each of those cases, the shooter, I think, was killed.
I think you're correct.
Had they survived, they would have faced capital murder charges. I don't know what Connecticut's law is.
I don't know their law.
But for sure in Florida, they would have. The only thing is, if the people are standing on the sidewalk, a school child, and somebody shoots him, that doesn't come under this bill. But if he was standing 1 feet farther over off the sidewalk, which is VDOT, now onto school property, that totally changes the crime. Almost all of these school shootings have been multiple killings. You know, there may be some I don't know about, but most of them, if they make the newspapers, seem to have been multiple killings. They already qualify for capital punishment on the assumption they're 18 or older, which in all the cases that I can remember reading about, they were. And that's why I don't see where this adds, and you know, as you know, I've been a proponent of capital punishment. I just don't see where this really adds a whole lot to the statute. That's all.
Mr. Chairman.
Mr. Chairman, just to respond, it just fills a small void that's still open.
All right.
In trying to deal with the mass shootings in schools.
Benjamin.
Mr. Chairman, and I mean no harm to the bill. It's certainly well motivated. But this is a point at which staff's obligation is to point out a couple things. Number one, we don't have any other characters of capital offenses that are based on location. This would be the first, which raises, again, another obligation that we advise the committee that this then risks the further Christmas tree effect. Not only what Senator Morrissey referred to in adding another type of capital murder, but also another beginning a series of what would undoubtedly be well-deserved additional location offenses. You could make the same argument for murders that occur during church or in places of worship, daycare centers, hospitals.
You know, there are many other places that are equally deserving of this kind of attention. And so this is when we point out, without meaning any harm to the bill, what the likely consequences would be if we start identifying locations that have special protections.
And Mr. Chairman, I appreciate Mr. Benjamin. He's right. That could evolve into a much larger Christmas tree. Right now, I'm focused on school children in schools. I can't tell you during this last election how many times I went and talked to mothers in Stafford, Prince William County, Spotsylvania County, and they didn't ask me. They were yelling at me. What are you going to do to try to help keep my children safe in school? Well, this was one of the things I came up with. There are a list of things that I've filed this year to try to help. But this is one of the things to help let it be known. You're not supposed to be firing rounds even 1 foot out of the school grounds.
Yeah. Senator Sasslaw.
The only thing I would say to that is, God forbid, as a possible solution, make it a little more difficult to get your hands on that gun.
Yeah, Senator Boysko.
Mr. Chairman, I'm happy to have that discussion with Senator Sasslaw anytime he'd like to have it.
Senator Boysko.
Sure. So just one question. Of all of these mass shootings, do we know that the people were even concerned for their own lives? I mean, most of the mass shooters have died during these encounters, fully knowing that I believe. I don't see that this is going to be a deterrent to anyone who is ready to do a mass murder. And I'm just a layperson here. I'm not an attorney, but this doesn't seem like it would stop anybody from deciding to do something that crazy and horrible, thinking, oh, I might have to go to prison now. Like I don't think that's part of their calculation. But I appreciate your effort here. But I'm.
Mr. Chairman, in response to Senator Boysko, I think that could be said about almost every law we pass. But the idea is, if you have someone who's going to kill children in school, we don't ever want them getting out of prison. That's the idea here, if they're not already shot. So I appreciate that. I'm not sure our laws, in many cases, are deterrents as much as we've got to protect children who are in school from being shot. That's the idea my bill addresses.
Senator Morrissey.
And I'm going to be brief. With regard to what has already been said, that this language only deals with one person and not multiple shootings. Additionally, there's a component of it that I just do not fundamentally agree with, and that's the mandatory minimum term. Just so that my colleagues, and I think you and I know this, in those cases of capital murder where the jury can deliberate life or death, that's the only two options. If they come back and give life, the judge, who has been the fact finder and listening to it, can suspend a portion of it, and I don't want to take that discretion away from him. Your bill does take that discretion away. That's another point that I have a problem with. So if it's appropriate at the appropriate time, Mr. Chairman, I'm going to, with all due respect to the senator, I have a motion.
And Mr. Chairman, that was intentional on my part.
Okay.
Because if you commit a mass shooting in a school, I do not want the judge to be able to suspend any part of your sentence. So he's exactly right, and I have great respect for the gentleman.
Well, again, mass shooting is covered otherwise. Okay. Yeah.
Maybe.
Is anybody want to speak in favor of the bill? Anybody want to speak against the bill? All right, here we go. Okay, Laurie Hollis, in favor of the bill? Okay. Against the bill?
Yes, sir.
Okay.
Good morning. My name is Lori House. I'm with the Coalition to Stop Gun Violence. We oppose the bill. If the senator, and I respect his intentions, is going after deterrence, this is not going to deter anybody. Most, if not all, mass shooters in school settings get their firearms at home. If we could disarm these students before they are able to go out and do harm, we could certainly look at making requirements for safe storage in the home, and that would go much, much, much further. Person intent on doing this kind of harm wants to die himself, and he wants to take as many people with him, school students, teachers, as possible. If we truly want to stop school shootings, we would do more to protect students from access to firearms in the home. Thank you.
Okay, next.
Good morning, Mr. Chairman, members of the committee. Virginia Podboy with Virginians for Alternatives to the Death Penalty. We oppose the bill for many of the reasons that the committee's already spoken to. Thank
Okay.
you.
Anybody else want to oppose the bill? All right, is there a motion?
Mr. Chairman?
Yeah, Senator Obenshain.
Before a motion's made, if I could just say, you know, I listened to a couple of these comments, and it's interesting to hear that we're not interested now in deterrence, and that when we talk about somebody who's killed children, we don't want to punish them. When just a week or so ago, we talked about these ordinances that local governments were going to pass, and many of the same people were lined up in the audience to talk about the important deterrent effect that these ordinances by local governments were going to have in deterring people from bringing firearms, people often with murder in their heart, bringing firearms to craft shows and farmers markets in communities across Virginia. It seems to me that the very same people who supported that ought to double down in support of a good bill like this.
Okay, is there a motion? Been moved and second, is it been seconded?
Second.
Been moved and seconded to report the bill. Any discussion? It's been substitute motion to PBI, pass by indefinitely the bill. Is there a second? Second. All in favor of the motion to pass by indefinitely the bill, vote aye. All opposed, vote no.
Ayes 9, no 6.
Ayes 9, no 6. The bill is passed by indefinitely. Senator Stewart, you want to go
Mr. Chairman.
forward with your Board of Court Reporters?
Yes, Mr. Chairman.
Okay.
Senate Bill 334, Mr. Chairman, because I think there are a lot of witnesses here for this bill that have come from across the state. So I'm going to be really brief. It just creates the Virginia Board for Court Reporters as a board to establish the qualification for members to serve as court reporters. So it's regulated profession going forward rather than what it is now. And I'm sure there are strong feelings on either side of this issue, Mr. Chairman.
All right, we'll give 3 minutes aside. Can we do that? Okay, go ahead.
Good morning, Mr. Chairman, members of the committee. John Stirrup, representing the Virginia Court Reporters Association. We want to thank Senator Stewart for bringing this bill forward. The bill addresses
Mr. Chairman, I apologize to Mr. Stirrup, but I do
There's
need
a
to move
substitute. There's a substitute. First of all, is there a motion to adopt the substitute?
So moved.
And
Second.
all in favor, and it's been moved and seconded to adopt the substitute. All in favor of adopting the substitute, say aye.
Aye.
All opposed, no. The substitute is before us. Senate Bill 334.
And it just mirrors it to the House version.
Okay.
A small change makes it.
Okay. Yeah. Go ahead.
Thank you again, Mr. Chairman. Currently, there are 40 states that have some form of licensure for court reporters. This bill addresses perfection of the record and raising the standards of the profession. I have several court reporters with me today who have traveled throughout the Commonwealth to be here. In the interest of time, only one is going to speak, Cindy Bragg from Bristol. And I also want to mention that Leslie Etheridge, who is the president of the Virginia Court Reporters Association, was here earlier but had to leave to participate in deposition. So, Cindy Bragg.
Okay.
Thank you, Senators. As was mentioned, my name is Cindy Bragg, and I'm from Bristol, Virginia. I'm a court reporter down there that covers Southwest Virginia. I want to first begin by talking about how the climate, the landscape of the court reporting industry has changed over time. In the past, as court reporters as independent contractors would work for local court reporting firms, those firms would train the court reporters, oversee their work, schedule the reporters to cover jobs according to their skill and experience. They would also keep abreast of the changes to the Virginia Rules of Civil Procedure and deal with any kind of issues that may arise. That was a level of protection for the consumer. There is now a rise of national court reporting firms. So, for example, today I may work for a firm that is out of Nevada, tomorrow Florida, perhaps after that New York. Those firms do not do the same thing that the local court reporting firms used to do, and some still do. There are still some local firms, but they have shrunk. So that because of that, there's not that level of protection for the consumer as there was. There is now, what we do now when an issue arises as court reporters, we tend to take to social media and say, I've had this occur, what would you do? And whatever the most popular answer is, that's what we go with. And I suggest that's a very precarious way to run a profession. There are issues that have arisen with the diminishment of that level of protection. The complaints of malpractice of court reporters have risen across the Commonwealth. The Board for Court Reporting would, to protect the consumer, would set minimum standards of competency across the Commonwealth. There would be no barrier to entry. In fact, it would create an apprenticeship program like other skilled trades have. It also includes all forms of methodology across the Commonwealth. It would create a registry which would help with any scheduling of court reporters. It would also help with transcript retrieval. It would provide a board to answer questions that would arise, and it would be a body to handle any kind of reporter malpractice.
The question I have, time has expired, but is there no board at this time in Virginia?
No, sir. There are national associations and the Virginia Court Reporters Association. Though none of those deal with any kind of complaints regarding court reporter performance, none. I have a lot more to say, but I know my time has expired. But thank you so much for indulging me.
Those that's in support, raise your hand. Okay, thank you. All right, those against the bill? Come on up.
Thank you, Mr. Chairman. Alexander McCauley on behalf of the Virginia Court Reporters Federation and the American Association of Electronic Reporters. We oppose the bill. This has been studied numerous times, and there's never been found by DPOR or any other body studying this of the need for this regulation. The key point I want to make to you is that this creates an independent board of court reporters. This is not something within DPOR. This is an independent board that's going to have to lease its own office space. It's going to have to hire staff, get IT, all these kinds of things. The only parallel for this would be the State Bar Association or the Board of Accountancy, which are huge professional groups. You've got 500 maybe people who would be licensed by this board, and they're going to have to bear the cost of this board. We estimate that it would be $500,000 to run this board, lease the office space, do all that. That could result in dues to these people of $1,000 each.
Let me ask you a question. If there's a complaint now, who do you complain to, DPOR, and what happens?
They can file a complaint with these national associations. But again, remember
when they're waiting for a deposition transcript or a court reporter who's ghosted, that doesn't do you any good whatsoever.
Okay.
Sorry, Alexander.
Well, that's
Senator Obenshain, by the way.
That's okay, Senator Obenshain. You know, our view is that the public is not threatened by these court reporters. They're hired by attorneys, state agencies, and court clerks. These are sophisticated consumers. If there's a bad court reporter, they can stop hiring them.
Okay. Next, you got 1 minute to go.
My name is Neil Gross. I am a court reporter here in Virginia. Moved from Craig County to Arlington in 1975. I talked to one of the senators earlier and said, "You couldn't have been doing it that long. Must be my young face or all my gray hair." 45 years I've been doing electronic reporting, originally called electronic. Today it's known as digital. And the problem with this bill is it's not really needed. There's the national associations right now have code of ethics. They monitor and regulate all the forms of the steno mask and the electronic digital. All the associations are mentioned in the proposed legislation, and this bill essentially allows this independent board, a new agency within the state, to piggyback on the certifications of the existing associations.
Okay. Thank you. Your time has expired. Go ahead very quickly.
Essentially, this bill confers on the Virginia Court Reporters Association the ability to nominate and to regulate any new entries into the field. And since they're, not only are they stenographic writers of shorthand, they are, in their bylaws themselves, they're prohibited from even recognizing the legitimacy of digital electronic. And I look around this room and I see lots of digital electronic services. This is the 2020, it's the 21st century, and it's really an unnecessary burden to the mom and pops to be paying for a new state agency that's absolutely unneeded and wasteful.
Okay, this has got to go to finance if it's reported. Would you like to come up and say who you are very quickly and where you all from, basically?
I'm Rick Russell. I'm here for the American Association of Electronic Reporters and Transcribers, AAERT. We're the National Association for Digital Reporters and Transcribers. This bill would directly impact negatively our membership in Virginia and people who work in Virginia. We weren't consulted on the bill, and we would basically be regulated by the VCRA.
Senator Stewart, would it outlaw digital court reporting?
I don't think so, Mr. Chairman, not that I was aware of.
Absolutely not.
It's in your bylaws.
You did not, you didn't.
Oh, okay, okay, let's go. Just, would y'all raise, where are you from?
Very briefly, my name's Joseph DeMonte. I'm one of the founders of Planet Depots. We have offices in Tysons, Norfolk, Richmond, throughout the Commonwealth. We
Where are
work
the
with
rest of the people from?
So these are some independent reporters. Just to be clear, if you want to hire a certified reporter now without this bill, you can do that.
Okay.
We don't need a bill for that. Thank you.
Okay. All right, how many of you all are here? Okay. All right.
My name is Anthony Vorndran. I'm a certified electronic reporter through AAERT. I work here in Richmond. I oppose this bill. It will directly affect my business. Thank you.
Okay. All right, Senator Stewart, you want to wrap it up?
Mr. Chairman, the only thing I would add is we're not trying to injure any form of court reporting. We're just trying to bring it together under a Virginia standard and governed by a Virginia board that addresses that, just like we are in the state bar.
How do you answer the question? They
But
say
an interesting, let me
dispute
point
the
out one
fact.
thing to
Okay.
you, Mr. Chairman. You know, currently you could be convicted of a felony for lying, cheating, or stealing and continue to be a court reporter in the courtroom. And that's a pretty interesting thing. And so that, in and of itself, is probably a good reason we ought to pass this bill.
And you're saying it would not outlaw the digital?
Not outlaw these other,
They
not
say it
outlaw
does,
these
you
other
say it doesn't.
versions.
Okay.
My bill does not. No, sir, it does not.
Mr. Chair.
Yeah, go ahead, real quickly.
Hello, my name is Jim Cudahy. Importantly, I previously was CEO of the National Court Reporters Association, which represents stenographers. I'm now the CEO of a new organization called the Speech to Text Institute. What is not being talked about at all today yet is the fact that there is a chronic gap between the supply and demand of stenographic court reporters. The industry is in a significant state of flux, and no one has yet talked about the fact that this would end up being an unnecessary board and complicate an industry that is going through a tremendous transition at the moment. It hasn't been needed until now. There's no good reason for it at the time.
Mr. Chair.
Yeah, Senator Peterson.
I'm ready to make a motion on this bill.
Go ahead.
And first of all, I practiced law for 26 years, and I can't think of a profession where reputation is more important than court reporting. Every court reporter I've ever used is somebody I know and trust based on the quality of their work. I would not order them for any of my transcripts unless I knew that it was going to be delivered timely and accurately. If a transcript is inaccurate, there is a method by which you can correct it. The bottom line is this is a profession that actually works pretty smoothly right now, oddly enough, without being state licensed. I know that's a shock to some of us. So I with all my respect to my great friend Senator Stewart, I'm going to move to PBI this bill.
Mr. Chairman.
Senator Obenshain.
Yeah, and I would, I hate to do it, and I do it with trepidation, but I respectfully disagree with my colleague down at the other end of this bench. we do rely heavily on court reporters, and I do not have the opportunity to pick the court reporter I use in every case. I wind up at the mercy of my opposing counsel, and Senator Peterson knows full well that in some cases you have somebody on the other side with a deep pocket and is scheduling deposition on top of deposition, and they are the ones who are picking the court reporters, often mandated by their clients to pick a particular court reporting agency and for reasons that we've discussed in years past. And we wind up being stuck with the pricing, with the court reporter that they choose to send. If I call some national agency, I don't get to pick the court reporter. Certainly, I don't get to pick the court reporter if my opposing counsel does. I just encountered a situation a couple of weeks ago in which it was brought to my attention that there's a case in which court reporter just basically disappeared, and the transcripts could not be produced. I think that given the reliance of the parties in civil litigation and criminal litigation upon these important parts of the process, I think that we do need some oversight. If somebody disappears, you really, short of going to get an injunction from the court in which the case is pending, you've got no remedy whatsoever. So, I hope that we would not pass this bill by indefinitely, and I would respectfully make a substitute motion to report the bill, and maybe the patron would consider seconding that motion. Second.
So substitute motion to report and re-refer to finance. Is there a second?
I second it, Mr. Chairman.
Okay. All in favor all in favor of the motion to report the bill and re-refer to finance, vote aye. All opposed, vote no.
Didn't make it.
Ayes 5, noes 10.
That was a bipartisan death. Thank you, Mr. Chairman.
Sorry?
We got a hanger.
Shall we reverse the vote? Okay. Reverse the vote. All in favor say aye. All opposed, no. Okay. Senator Anger.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. Senate Bill 964. Mr. Chairman, members of the committee, Senate Bill 964 is fairly simple in concept. It would add private police officers or police departments that are accredited law enforcement agencies to the definition of law enforcement officer for purposes of crimes of assault and battery. Mr. Chairman, this was requested by the police department at Wintergreen, but I also represent portions of that, but I also represent Massanutten. I do too. I think Senator Norment has engaged on this subject with these departments before as well from his area. That is what the bill would do. There have been some additions over the years, Mr. Chairman, and I have a supporter here who is the Executive Director of the Virginia Association of Chiefs of Police, and she would like to essentially have this be a substitute that would, by definition, in Section 101, include this group and some others. But my bill would just seek to add these accredited police departments.
Okay.
Mr. Chairman, Dana Sherrod from the Virginia Association of Chiefs of Police. The assault and battery statute, when it comes to defining a law enforcement officer, has always been somewhat Swiss cheese. We've added things, but we've been very inconsistent with the definition of law enforcement officer in this code section for a long time. For example, the Metropolitan Washington Airport Authority is in there, but no other airport police department's in there. Campus police is not in there. But when we add private, for example, here, there may be some confusion in terms of definition. What is a University of Richmond police officer, which is a private police department? Are they a private police officer or are they a campus police officer? So here's what we would like to suggest. And this would have to be a substitute, and I've sent a draft to Mr. Benjamin. In paragraph C, where it points to an officer as defined in subsection F, it should point instead to the definition of law enforcement officer in
What line?
I'm sorry, I don't have that line. It's in subsection C, after such person as a judge, magistrate, law enforcement officer as defined in 9.1-101 is what it should say instead of subsection F.
Okay, which line is that? We have a line?
24.
24,
Yeah, thank you.
and it should say, what's that again?
Instead of subsection F, strike that and insert section 9.1-101. I'll start by just explaining that that incorporates all the certified law enforcement officers in the state, including private law enforcement officers in recognized private police departments.
Counsel, is that correct?
Mr. Chair, I do have one concern about the suggested amendment. The definition of a law enforcement officer in 9.1-101 doesn't include all of the defined law enforcement officers in the current section.
I've got that covered.
All right?
Thank you. But so really to fix this, we need to fix what's in paragraph C and then go down to that later paragraph F and clean up that definition of a law enforcement officer. All this would be consistent with 9.1-101, but it also would still include those correctional officers, auxiliary officers, and fire marshals and school resource officers that would be, we would retain them in the assault and battery statute.
Does this need to go by temporarily to get it fixed?
Yes.
Yes, okay.
That would be
Mr. Chairman,
With that,
Mr.
yes.
Chairman.
Yeah, Senator Searle.
Well, I'm not detecting a lot of positive vibes on the bill generally, but I mean, so I'm not sure if we want to
Well, why don't we
keep the discussion going.
see if there's a way to fix it. Without objection, we'll go by temporarily.
All right.
To see if we can't come up with something.
Okay.
Okay. All right, thank you. Senator Hanger, anything else at this point?
That's my bill, and I will just need to
Okay.
see if we can work something out. All right.
Okay. While we wait on that, moving on to, yeah, Senator McClellan. Yeah. Senator McClellan's got a bill. Chickahominy.
I guess that's the easy one. I do have
Okay.
someone who wanted to testify on the other one. so,
Okay, Senator.
Looks like
Senator.
724 is up, so that is, Senate Bill 724 would change the statute of limitations for sexual offenses against a minor from, currently it is 1 year after majority, so when that person reaches 19, this would change it to 5 years after majority, or when they are 23. The reason for the bill, frankly, when you have a child who has been sexually abused, oftentimes they are not ready to come forward, even in that first year. It sometimes takes them a little longer to get over the trauma of what has happened to them. But I would like to have Fatima Smith, who asked me to carry this bill, tell you her story. She is the impetus for the bill, but there are many others who are in similar situations, including my own legislative aide, who also would like to share her story.
Okay.
Matt.
Thank you.
Mr.
Yes,
Chair,
Senator
I
Dees.
mean, I appreciate the impetus for the bill. I introduced this bill last year at the request of the Commonwealth Attorney, and one of the Commonwealth Attorneys in the localities that I represent.
Okay, thank you.
And, okay. It's got to go to finance, of course. Go ahead.
Good morning, Chairman and the members of the committee. My name is Fatima Smith, and I support Senate Bill 724. I was an all-star cheerleader, and at the age of 11, my cheerleading coach entered my home after I left my keys in his car on a Monday morning when my parents were away at work. He came into my house, went into my bedroom, and I woke up to him touching me. And I remember him stroking my face saying, I was wondering how long it would take for you to wake up because I've been touching you for a while. He then proceeded to pull back my sheets and pull my pajama bottoms down, and I didn't have underwear on, and he was asking me if my pajamas were silk and continued to touch me. I remember pulling my sheets up and being very startled, and I didn't say anything because I kept focusing on what my mom said about somebody touches you, it's wrong, but it was my coach. And 6 months later, he was then charged, and it was in the newspaper. One of my cheerleading friends and I were talking about it, and she disclosed that it was actually her, and she shared some details, and it made me share what happened to me. And ultimately, my parents and I decided not to press charges at the time because they were receiving death threats and hate mail, and another girl ended up coming forward. The case was acquitted. There was so much community support for this coach. Fast forward 10 years, he then was charged with, I think, 11 counts of felony, rape and drugs and alcohol consumptions of minors. He was found guilty and sentenced to 20 years. However, when I wanted to come forward in 2011, I was told that the statute of limitations had run out. And the prosecutor, while being empathetic, was unable to move forward, even though this would have been an excellent demonstration of his grooming behavior back in 2000 and 2001. And it was a different kind of trauma to not be able to tell my story. And I'm here to speak on behalf of the 2 girls that didn't get justice in 2001, and myself and other survivors who need to be heard and just don't have the time to process because they're still enmeshed in the culture. I was still cheered up until college, and so it wasn't until my adulthood when I had the opportunity to be supported by my friend Abby, and realized that I could share. And so I just really hope that you will find that this is a need and that there is so much research that substantiates that survivors only speak later in adulthood.
Mr. Chair.
23 seconds, yeah, Senator.
Just to make I guess, an obvious point to me, but not everybody realizes it, this is a misdemeanor. A felony, there is no statute of limitations.
Correct. And
Okay, so hold on a second. So a misdemeanor, I appreciate your testifying, but a misdemeanor is going to be a much lesser violation than a felony would be. It would be, for example, touching somebody on their buttocks without permission or something like that. So it's not breaking into somebody's home, which must have been a horrifying experience. That, to me, would seem like a felonious behavior. So I don't see how there could have been a statute of limitations issue there.
Okay.
The statute of limitations was on the fact that he actually touched me non-consensually.
Mr. Chair?
All right. Senator Morrissey.
Following up on what Senator Peterson said, first, I'm not quite following it because the offense that you described was a felonious breaking and entering with the intent to commit a felony, and it was also a felonious sexual battery because of your age. So you could prosecute that case right now.
I was told I couldn't.
You can.
Okay. All right, well, all right.
Mr. Chair.
Let's hear the rest of these. You got 19 seconds.
Mr. Chair, one issue that was raised last year with this bill is that it could be dealing with the juvenile on juvenile offenses. And so we had an amendment last year to impose a tighter limitation on that sort of offense. Do you remember that amendment, Charles?
Yes, Mr. Chairman, I do. Basically, the section that's being amended would be changed from 5 years. It would essentially read the end, unless the alleged offender of such offense was an adult, in which instance such prosecution shall be commenced no later than 5 years after the victim reaches majority. So it does take the 5-year period and just make sure that the people committing the offenders are adults and not juveniles.
Okay, you want to move that amendment?
I'll move that amendment.
Senator McCollum?
I'd second.
Okay, all in favor of that amendment, say aye. Aye, all opposed, no. Motion carries. All right, there's 19 seconds. Say who you are.
Hello, Chairman and members of the committee. My name is Abby Phillips. Just before I turned 13 years old, my karate teacher took me into his bedroom, locked the door behind him, sat me down in a chair, and started to
It's okay.
Stood behind me. I'm sorry, I've never spoken about this publicly before.
You don't need to apologize.
You take your time.
He stood behind me and fondled my body while sucking on my neck. I was completely paralyzed. I couldn't understand or process what was happening. The next day when I woke up and found bruising all up and down my neck, I didn't understand why someone's mouth could leave bruises on my body. Confused, I pondered if my karate teacher was just doing something trying to help me. Maybe he understood something I didn't. He did understand something that I didn't. I was a child. I trusted and depended on his judgment and actions as a leader and teacher in my life to keep me safe. This is a man my family trusted, our community trusted. His children were my peers and friends. It took me almost a decade to process and understand what happened to me. I was well into my 20s before I told anyone. When I started to talk about what had happened to me, I found out that this had happened to many of my peers by this same man. I knew I had to go forward. By the time I decided I could report this, the statute of limitations had long passed. I am standing here today asking you to please consider this bill, not just for me, but to protect many children in our communities. Thank you.
Thank you very much. Senator McCullough, you got somebody else back there you want to introduce?
I'll move the bill we reported and re-refer to finance. Second.
All in favor of the motion to report the bill and re-refer to finance, say aye, vote aye. All opposed, no. Yeah, a substitute, yeah, substitute bill. So the substitute, yeah, clerk?
Ayes 15-0.
The substitute has been reported and re-referred to finance by a vote of 15-0. Senator McCollum?
Thank you. Senate Bill 1076 would authorize the governor to convey 2 parcels of land located in Charles City County to the Chickahominy Indian tribe. Here to speak on behalf of the bill is Chief Atkins of the tribe. This is a piece of land that hundreds of years ago was part of the tribe's ancestral lands, and this is just an attempt to return to them land that was once theirs. And Chief Atkins is here to speak on behalf of the bill.
Somebody from the Chickahominy Indian tribe?
Yes.
Good morning. I'm Stephen Atkins, Chief of the Chickahominy Indian Tribe, and I'm coming to you today in an effort to restore ancestral homeland to my tribe. We just commemorated 400 years of the first convening of this august group, the General Assembly. 27 years after that convening, that same body chose to move my people from the ancestral land about 50 to 60 miles distant to what's now King William County, along the Mattaponi River and the Herring Creek. So 1646, an act of the legislature of the Commonwealth forced us off our land. Today, land has become available, ancestral land along the Chickahominy River. Several things have happened in the interim. The College of William and Mary disinterred 2,500 disarticulated human remains from along the Chickahominy River. So what I would like to do with this property is repatriate culture, land, and place. And those remains that are housed at the College of William and Mary will be reinterred on the property. If we're successful in getting this property, we will lay these remains to rest, ancestral lands from which they were taken. With some misgivings, we had some of those remains carbon dated, and they date to 600 AD, so a rather extended presence on that property. Okay. So it's our request we're appealing to you to provide funds for the Chickahominy tribe to repatriate this land, this
Okay.
ancestral land, from which we were forcefully removed in 1646.
Okay, any other speakers? Any questions to the
Mr.
speaker?
Chair. Oh, I'm
Yeah,
sorry.
Senator Morrissey.
Set for the patron. It's good to see you, Chief.
Good to see you.
I'll preface my comments that I used to represent Charles City County in the House. First question is, the portion that the chief just spoke about, that's not part of your bill, is it? This is just to convey the acreage, am I right?
So the part where that is part of William and Mary is not. I think his point in telling that story was that the hope is that they would reinter these individuals on the property that they're going to get, that will be conveyed.
All right. And can I assume that the Board of Supervisors in Charles City County is in support of this?
I'm confident they will support it. I haven't talked to the whole group. I've talked to a couple of members.
Okay. Final question, Mr. Chair.
Yes.
Jennifer, would it not be appropriate to, before we do this, to make sure that the Charles City County Board of Supervisors is in agreement with this?
So this is currently private property, and that would be
Owned by
purchased
William
and- No, it is private property that would be purchased by the Commonwealth and conveyed to the tribe.
Mr. Chair.
Senator Peterson.
Okay, so it's private property. You'd have to condemn it. I mean, what if they don't want to sell to you?
It's for sale.
Oh, it is for sale?
Yes.
Okay, do we know what the price is?
I have a budget amendment for that amount, I believe. Do you remember?
This needs to go to finance?
Yes. It needs to go fine.
All right, is there anybody else who wants to speak in favor or against the bill? Yes, Senator Norman.
Thank you, Mr. Chairman. I'm very familiar with the property owners and the transaction that's being put together on this. And the chief and I have spoken about this as well. And based on conversations that I've had with some of those in Charles City County, they're receptive to it, but it is private property. So I'd move to report the bill.
It's been moved and seconded to report and re-refer to finance. All in favor of the motion, say aye, vote aye. All opposed, no.
That's 15-0.
The bill is reported and re-referred to finance by a vote of 15-0.
Thank you, Mr. Chair.
Okay, Senator Lucas wants her Senate Bill 949 to go by for the day. Is there a second? But without objection to go by for the day. And what else do we have? Hanger, how are we doing, Senator Hanger?
Mr. Chair?
Yes.
We spoke briefly earlier about my death penalty moratorium bill, Senate Bill 802. I can't remember what you and I agreed we were going to do on that. Mine is a moratorium on the death penalty until the other death penalty bills. I think Senator Serville may have one. I think another individual has one.
Let's have them go by until, take them all up at the same time.
All right.
How's that? The death penalty bills, take them by for the day.
Mr. Chairman.
Yeah.
Would you say you want to take my death penalty bill by for the day?
I believe so.
Because I think there's at least, I don't know, there's one witness here to speak to. I can check and see if he can come back. I can check with him. The gentleman who spoke earlier, who was the executioner. If you give me a second, let me go check in with people.
We dealt with one of them earlier. Okay. Okay, Senator Hanger?
Thank you, Mr. Chairman. Staff had indicated that they were working on, it was going to require a substitute if we adopted the recommendations of the Police Chief Association. My interest is for Wintergreen right now. Wintergreen, of course, it would pick up Massanutten as well, that they would be included in this definition of private police officers where assault against them would, under the assault and battery provisions. So I'm not sure whether they've been able to do that yet or not.
Mr. Chairman, I do have the suggested new language.
Okay.
And basically, the suggested new language would be on line 24, replace subsection F with defined in 9.1.101. And in that subsection C, we would also insert the language dealing with fire marshals. So essentially, fire marshals appointed to 27-30 when such fire marshals have police powers as set out in sections 2734.2 and 2734.2:1. And then the remainder of the statute, the firearms definition, would be stricken because the law enforcement officer would be defined as it is in subsection C. So that language in the rest of the bill on lines essentially 63 through 78 would be superfluous because it's already defined under subsection C. That would be taken out.
Mr. Chairman, my intent was just to make sure that private police departments, such as are at Wintergreen and Massanutten, would be included in this provision. There was the assertion from the police chiefs that they're trying just to clean up the whole section rather than leaving it as a Christmas tree. So if you can speak to that.
Mr. Chairman, members, it's Dana Schreiber with the Police Chiefs Association. The statute has been inconsistent with the definition of law enforcement officer in 9.1-101 for some time. This is just a means to clean that up so it is consistent. Those are officers who are subject, obviously, to certification and decertification, which we have imposed on our private law enforcement officers across the Commonwealth. You may recall a few years ago when we did that massive legislation that for them to be recognized, they had to meet all the certification, training, decertification requirements. So this is just really creating a consistency in the code in terms of law enforcement officer definitions.
Mr. Chair?
Yeah, Senator Peterson.
And I'm going to push back a little bit against this concept because I understand the training may be the same, but how should I put this? The office itself is not the same. And let me make the point that when you strike a police officer, you're actually committing a crime against the state. You're literally striking the sovereign. If I get into a fight with, the security officer at King's Dominion, that's not the same thing. And we have stretched this definition and stretched this definition and stretched this definition. And once we get private police forces that may be chartered by some private organization, Wintergreen or maybe even a quasi-public one like an airport, I think we get further and further away from the intention, which is, again, the sovereign is who you're striking when you strike a police officer. It's not the same when you get into a tangle with a security officer. And I'm not saying that's good either, but I just feel like, if anything, Dana, we need to be pulling back this definition, not broadening it.
Mr. Chairman, Senator Peterson, I couldn't agree with you more. We are very strict in terms of who we want to define as a law enforcement officer in Virginia. That's already been addressed in 9.1-101 where they are identified as certified law enforcement officers, and they are subject to every other consideration. And for a private police department, by the way, to be recognized in Virginia, they have to come to this General Assembly and have a charter recognized. So they cannot be created willy-nilly. And unfortunately, that's what was happening some years ago when they were being declared private police departments without any code language, which is why we came to the General Assembly to fix that.
Mr. Chair?
Yeah, Senator, Morrissey.
Thank you, Mr. Chair. Did I hear you say earlier that the campus police at VCU and the University of Richmond are not covered?
Yes, Mr. Chairman, Senator Morrissey, that's correct. That's because of the definition of law enforcement officer and assault and battery has been one of these Christmas tree statute that has added things in somewhat of a unorganized fashion.
Mr. Chairman?
Senator Morrissey.
I think Senator Peterson captured it best when he talked about the elasticity of this language being stretched. I mean, I've got the greatest deal of respect for the VCU police officers, U of R. They're not covered, but you now would be covering a private police officer at Massanutten who doesn't have 1/10 of the training that a VCU police officer has.
Mr. Chairman.
Mr. Chairman.
Senator Overton.
That's just not so. I mean, Massanutten it's like a town. And its police officers they're not security officers. They are not riding segways around. These are police officers with arrest powers who've been through the academy. They are trained.
I stand corrected then.
And same with Wintergreen, and same with Bridgewater Airport. I mean, these are charged with protection of large number of citizens, and I won't argue with you about VCU police and whether they ought to be covered, but the question is, these are police departments. We have, as the sovereign, designated these as police departments and police officers, and this protection just hadn't been applied to them.
And Mr. Chairman, if I may, the amendments that I have brought to the committee would bring our campus police department, our campus police officers into alignment with this code. So it really is meant to be consistent with, if you are a certified law enforcement officer in the Commonwealth of Virginia, you are covered by this assault and battery statute.
Okay, any other questions? Senator Hanger, anybody opposed to the bill?
Mr. Chairman.
Is there a motion?
Second.
Mr. Chairman, speaking to the motion.
Yeah, we need to adopt the substitute. I want to read the substitute again. Do we have it in writing?
I don't have it in writing because I just got it and I was waiting for copies to be brought down. Copies are...
Oh, good. Just in time. Okay, you want to explain the changes in the substitute?
So essentially, the substitute tracks the definition of law enforcement officer in 9.1101 and also includes the fire marshals who are already protected under the assault and battery statute. And it seems to also track any other statute, like the malicious bodily injury to law enforcement officers, and the pointing of lasers at law enforcement officers. So any of those, I'll say, crimes against law enforcement officers will track the language of who is a certified law enforcement officer in 9.1101 as opposed to the existing definition of law enforcement officer in the assault and battery statute.
Mr. Chairman.
Mr. Chair.
Senator Searle.
Thank you, Mr. Chairman. Speaking to the amendment and the bill.
Include that this time. That's not
You
what
know,
you intended.
this statute is one of the biggest headaches that is on the books right now. I mean, I cannot tell you how many times I've seen people charged where they say nothing happened and the police officer said they did, and they're facing a felony. They have a massive amount of pressure to plead guilty. I'm really leery of expanding this to anybody. And if anything, I think we ought to be looking at going the other direction. And so I can't support the amendment. I can't support the bill. I just wanted to say that.
Mr. Chair.
We need to adopt the substitute. Is there a motion that we adopt the substitute? All in favor, say aye. All opposed, no. Motion carries.
Move to report and re-refer to findings.
Okay, it's been moved and seconded to report and the substitute and re-refer to finance. Any discussion?
That's crazy.
All in favor of the motion to report and re-refer the substitute, vote aye. All opposed, vote no.
Aye 6, noes 8.
6 to 8. Sorry, Senator Hanger.
Thank you, Mr. Chairman.
Try again.
Thank you.
Okay, thank you. Now, let's see, we are... Senator Searle, you have the next 5 hours for your bills. It'll take at least that long. Okay, which one do you want to start with?
Mr. Chairman, if you want to take the death penalty by so that it can be considered at the same time as Senator Morrissey, I think I'd talk to everybody out here, and I think they can come back Wednesday after we get off the floor.
Senate Bill 449, abolishing the death penalty, is by until the day, I guess, be Wednesday. Is that right? Yeah. What is yours?
My bill is 802.
802, that'll be go
And
by.
that's fine for the day until.
Yeah, as long as we can guarantee it can be done Wednesday, because there's a lot of people here to talk about it who've taken time off of work and stuff.
You want to do it Wednesday? Okay, we'll do it Wednesday afternoon. Okay. The two death penalty bills, Senate Bill 449 and Morrissey's, what's the number? 80. I'm sorry? Okay, okay, Morse's is not on the docket, it'll be on the docket, so. Yeah, Senator Norman.
Mr. Chairman, being realistically grounded and looking at Wednesday, I really don't want to be here till 10 o'clock at night. And I respect that the public wants to be heard from, but I would suggest as it relates to Senate Bill 449, there's not one member of this committee who doesn't know how they're going to vote on it. So I just, from a presentation standpoint, I would hope that uncharacteristically, it could be succinct.
Okay. All right,
Noted.
No, you're at 428, Senator Searle, right?
I was wondering who that was. Sorry, Your Honor? I mean,
Yeah.
Mr. Chairman.
428?
Yeah, let's do 428.
Okay.
428 is pretty simple. Right now, you can seek to recover the expenses of a pregnancy, but only if you file a paternity action. I think it ought to be if you also are seeking child support. You shouldn't have to challenge paternity to seek pregnancy expenses. So basically, this would say that if you file for child support within 6 months of pregnancy, you can seek to recover the pregnancy expenses.
Okay, is there anybody to speak in favor of the bill? Okay, here we go. Senate Bill 428.
Thank you, Mr. Chairman, members of the committee. Valerie LaRue from Virginia Poverty Law Center. We support this bill. We would actually like it even better if instead of being 6 months, it was 1 year. Because if a couple is married, they can't even get divorced until they've been separated for 1 year. And sometimes those hospital bills keep coming in over the course of several months. And so we like this bill. We're very much in support of it. We just think that 1 year would make it even better.
1 year before the birth of the child?
It says of the birth, within of the birth.
Oh, okay.
So it would be,
Okay.
the child would have to be born in order for the 1 year
Yeah.
divorce
I got you.
to
So
step into
is
effect.
there anybody, okay, comment? Okay, go ahead.
I'm Kim Ramsey with the Family Law Coalition, and we do support the bill as well.
Would you like to have it 1 year or 6 months?
We had not,
Okay.
we had not given that
All right,
consideration.
anybody against the bill? Is there a motion?
Move to second.
It's been moved and seconded to report. It does not need to
John.
go to finance. All in favor of
Finance.
reporting? It does? Does not. It does not need to go to finance. That's what I said. Senate bill, voting, all in favor of reporting Senate Bill 428, vote aye. All opposed, no.
Thank you, Mr.
15-0.
15-0.
Thank you, Mr. Chairman. Could we do 430 next?
So for Senate Bill 430.
Okay, 430, right now, by statute, parents can obtain access to their children's health care and educational records. There are,
Yeah.
The only question that relates to this bill is where's the term child care records defined?
it's not defined in this,
Is it defined anywhere?
I don't know. There's child day centers are defined in the code under 63.1. I know we just saw that in Senator Hanger's bill, but there's child care centers that actually refuse access to records because of the ambiguity. And I thought it ought to be clear, but
What is,
if we could refer to child day center in 63.1, I think that would provide a,
Is that broad enough to cover all the child care records that are out there?
I think so. I mean, I was just looking at it because of, maybe it was Senator Stewart's bill who had the child daycare center as mandatory minimum for killing somebody. Yeah, he had it included. For a death at a child, it was schools and child day centers. Anyways, I looked it up and it basically said anybody that cares for a child outside of their, it's not the child's home, is what it said. I did.
All right, Senator Shervill, if both parents have custody, they automatically get the records of the child. don't they?
I've experienced child care centers that keep separate files for different parents, so one parent can't see the other parent's file, and that's not how it works on education or healthcare. And so I think it ought to be the same on child care.
okay, can I ask a question?
But I want to clarify, if both parents have legal custody, they both get to see records.
Doesn't matter what custody they have, both parents get to see it no matter what custody they got.
Okay, so what's the bill do?
It makes it clear that they can review a child care center's records about their child. There's some child care records that refuse access to one parent because the other parent says, I don't want the other parent to see it.
Mr. Chair.
Senator Peterson.
Yeah, first of all, health and academic records are sort of standalone concepts. I don't know exactly what child care is. I mean, child care records could simply mean did you pay your monthly fee?
Yep.
And what are the communications with the parents, which,
Yep.
by the way, may involve the other parent.
Yep.
It may be, hey, don't let that SOB pick up my daughter on this day,
Yep.
I mean, there may be communications in there that, for lack of a better term, were either not to say they're legally confidential, but maybe they weren't to be meant to be shared in the light of day. I'm not quite sure what this is actually accomplishing for the best interest of the child, unlike academic and health, which are standalone categories to the merits of the child himself or herself.
Mr. Chairman, what I would say in response to that is that, first of all, if they don't want to just hand the record over, you can get it by subpoena, right? Which is right, right. But secondly, you're not supposed, any record about your child, you're not supposed to have to get by subpoena. You're supposed to be able to get it as the parent. And there are.
Okay, Mr. Chair, if I might follow, this may not be about the child, though, okay? You're assuming that the records are going to be about the child. An academic record is about the child, a health record is about the child. The child care records may be, again, about who's paying the bill.
That's right.
So that's not necessarily about the child.
Mr. Chairman, I would say that these records are requested, at least in my experience, in almost every single child custody case, because if there's dispute, because number one, there's a record about who dropped the kid up and who dropped the kid off and picked the kid up. People want to show who's doing it and whether, somebody not the parent's doing it. And people are trying to show who's involved and whether they're on time and whether they're picking the kid up on time and stuff like that. And you shouldn't have to issue a subpoena for these things.
Final point, Mr. Chair.
Yes, Senator Peterson.
These records aren't about the child. They're about the parent, though. The parent's trying to show, I paid this tuition, I picked up the child at this time. I mean, it's just a different category of the academic and health records of the child. The child care records are going to be about, the parent and paying the tuition and all that stuff.
Okay, any other questions?
I don't agree. I don't think the Family Law Coalition does either, but you can argue with them.
Anybody in favor of the bill, come up and speak in favor.
Hi, I'm Kim Ramsey with the Family Law Coalition. We do support this bill, and there are instances where parents try to get records and they don't get consistent records, from the child care agency, and it does actually come up all the time. Things, and just as Senator Serval was saying about drop-offs and pickups, but also the condition of the child on that day. If the daycare is making a note that the child is, comes in with a fever consistently with one parent, or comes in with one parent, without a jacket, we don't know all the things that different daycare centers may keep track of, but they could be very relevant in a child custody case. And that's why, and it's really no different. This is just protecting the younger children. It's the same thing that you get for school-age children, but it's protecting the younger children. And if you talk about who's paying what, that could also be in records of a private school. So, public school, no, but in a private school, you'd be getting those records as well. So it really is just protecting these, 0 to 5-year-olds that we don't have a way to get those records short of a subpoena.
Okay, anybody else in favor of the bill? Senator Short.
I wanted to make a point. The bill doesn't say child care agency, which is what the last witness referred to. It says child care. And as Senator Peterson pointed out and others, that is just a plethora of information. I'm not even sure who you direct it to. It's clear under health records, you know who you direct that, to whom you direct it. It's clear under academic, it's clear to whom you direct that to. But child care is not the same as child care agency or daycare center. Or
Senator Morrissey and then Senator Boysko.
I think if I'm wordsmithing this correctly, records on line 14 applies to the words academic, child care, or health. Am I misreading that, staff? And I think that's what concerns Senator Stewart. I looked at records on line 14 to apply to academic, child care, or health. Right. Am I correct? Okay.
Mr. Chairman, Senator Morrissey, that's correct.
Okay. When it's appropriate, Mr. Chairman, I do have a question of this. Of the page.
Go ahead.
Okay. Scott, what's the genesis of this? Does it have to do with family law and child custody matters? Because I'm sensing that there was an underlying problem that brought, and First of all, if you could just tell me what that is.
Yeah, so I've experienced, and as of other practitioners, that sometimes childcare centers don't want to produce records when parents are fighting, even though I think legally they might be required to right now. Number one, I've also experienced situations where childcare centers might even keep two separate files, one for one parent and one for the other, because they don't want the other parent looking at one. And that just, when it's a record about a child, both parents have a right to it. That's what the law has been in this state forever.
One final question, Mr. Chair.
Yeah, Senator Morsi.
What record of childcare would you be looking for? What is a classic example?
Again, pick up, drop off records, the things you just heard Ms. Dempsey talk about. You know, a lot of times you have parents fighting about, the kid didn't come with a jacket or they were sick and that kind of thing.
All right.
Also, the payment records are important because in terms of determining child support, what child care actually costs is the biggest factor impacting child support, and it's also a factor in determining arrearages if it hasn't been paid sometimes. And so you need access to that information, and I'm just trying to make it easy to get it without having to do a subpoena every time.
Yeah, Senator Boysko.
Thank you, Mr. Chairman. Just have an idea perhaps to clarify child care provider records from a child care provider. That way it would be more clear to folks.
I'm happy to take that amendment if it's friendly.
All right, it's moved and seconded that the word provider be added to child care on line 14. All in favor of the motion, say aye.
Mr.
Aye.
Chairman.
All opposed, no. Motion carries.
Mr.
Senator
Chairman.
Stewart.
Mr. Chairman.
Senator Obenstein. Is it Stewart or Stewart?
I thought maybe we'd want to ask counsel about that before we acted upon it.
Mr. Chairman, I don't see a definition for provider, but there is a definition for child day center.
Right, 63.100.
Exactly.
Yeah,
So
that's fine with me too.
All right, you want to change it from child care center or child? We just voted to make it child care provider.
Yes, it is defined.
Well, let's reconsider. Motion to reconsider the motion, moved and second, all in favor of the motion to reconsider, say aye. Aye, all opposed, no. Okay, so what is the motion?
The motion is child day center instead of child care.
As defined in 63.1100.
Okay, child day center instead of child care.
As defined in 63.1-100.
Is that proper? Okay, as defined in whatever you just said, line 14. All in favor of that motion, I think we moved and seconded it. All in favor, say aye. Aye. All opposed, no. The line amendment has been adopted. It's been moved and seconded to report. All in favor of the motion to move to report the bill as amended, say aye. Vote aye. All opposed, vote no. Motion. Okay.
Thank you.
15-0.
The motion is reported, is approved of 15-0.
Thank you, Mr. Chairman. Can we jump to 434 really quick? 'Cause I think that's the next easiest one. 434.
Child care assignment of tax credits.
Right.
Okay.
So after the last tax reform that came through, the federal government got rid of tax exemptions, and now everything's a tax credit. And this just makes clear that in a child support case, the court can also allocate the tax credit because the dependency exemption doesn't exist anymore. And the Family Law Coalition wanted to use this language about in any credits resulting from such exemption in case Congress went back to exemptions at some point in the future. And so this just gets the code consistent with federal law.
All right, it's been moved. Is there a motion? Any questions of this patron? Any opposition? Moved and seconded to report and refer to finance.
Finance?
Huh? It does not have to go to finance. Okay, it does not have to go to finance. Moved and seconded to report Senate Bill 434. All in favor of the motion, vote aye. All opposed, vote no. Okay.
15-0.
The bill is reported 15-0.
Thank you, Mr. Chairman. Now, 451, I think, is probably the next easiest.
Juvenile,
Right.
award of attorney's fees in the
Right.
J&DR court.
Right. So right now, basically, in any kind of divorce case, any kind of domestic relations, anything, if you're in circuit court, you can get the court has open-end discretion on attorney's fees. However, in a juvenile court, the court can only do attorney's fees based on the party's incomes. And a lot of practitioners and actually judges have told me they feel like this is too limiting. If somebody's really abusing the litigation process or brought a case in bad faith, they ought to be able to consider that in awarding fees. And so basically, this just would add in any other factors which would make juvenile court consistent with circuit court.
Okay, is
The
any
Family Law
question?
Coalition supports it too, I think.
One question.
Yes, Senator Morrissey.
Does this apply to criminal matters as well?
No. I don't know of any way you can get attorney's fees in a criminal matter.
Okay, no. All in favor, is it Family Law Coalition? Somebody want to stand up and? You support it? Anybody against the bill? All right, is there a motion? It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, vote no. Motion carried.
Okay. And if we could hop back to,
15-0.
The motion carries 15-0.
thank you, Mr. Chairman. You can hop back to 432.
432, spousal support, reservation right.
Yeah, this one's a little more complicated. So when somebody receives an award of spousal support, I'm sorry, when people are divorced, they can either receive an award of spousal support or they can request a reservation of the right to seek spousal support in the future, or actually a combination of the two. A court can say, I'm going to award spousal for a period of time and then a reservation for a period of time after that. However, the code is silent as to if you come back for support that you've reserved, whether or not you have to show a change of circumstances in order to get that support. And a Fairfax County Circuit Judge came down with an opinion where he found you do not have to show a change of circumstances in order to get that support. I've talked with the Family Law Coalition. They don't think that's the right way to approach it. They think that if you get like a 5-year reservation and you come back 2 years later, you ought to have to show a change before you get spousal support. And it's important to resolve this issue because this change of circumstances issue is a threshold issue, and people don't want to spend tens of thousands of dollars fighting about this if there's been no change. And there's also, I've heard there's judges that are applying it differently all over the state. And so we need to just have clarity on what the answer is. And this,
Senator Deeds.
yeah.
Mr. Chair, haven't other courts ruled on this, and don't most of them require material change of circumstances?
Yeah, I think courts are going both ways on it, and an appellate court hadn't decided it, and the Family Law Coalition thinks you ought to be required to show a change. And so this would just make it clear you have to show a change. But we don't have any appellate authority on this yet, and courts are all over the place on it.
Does the Family Law Coalition like to say something?
Kim Ramsey with the Family Law Coalition, and we do support this because it's just make it consistent across the jurisdictions.
Is there any opposition to the bill? Okay, opposition.
Mr. Chairman, Valerie LaRue from the Virginia Poverty Law Center. One of the things that we do is we operate an online divorce system that enables people to walk through a series of questions to create their own divorce filings. These are people who are not able to afford an attorney and either don't qualify for legal aid, or they go to legal aid and legal aid says, our waiting list is so long, it'll be 10 years before we could get to you. So those people are doing their own divorces. The questions walk them through most of the issues that someone is going to have, and it will kick them out if they have issues that they just cannot handle on their own. It tells them that if they are not asking for spousal support now, they must reserve the right for spousal support, and they're able to put that into their decree. My concern is that these are not sophisticated legal people. Many of them are may not even have a high school level reading level. My concern is that if they now have to not just reserve the right to ask for spousal support in the future, but they also have to put in there something about they're also reserving the right to not have to make a showing of a material change in circumstances, when they don't even know what a material change of circumstances is, that those people are going to be foreclosed from ever asking for spousal support in the future when their circumstances might support that. And some of those cases might be where someone thought, well, I don't need spousal support, I can make it on my own. And then after a couple of years, they realize, well, actually, I can't. Their circumstances haven't changed. Their thinking about it has changed. And I fear that by requiring them to prove this, rather than just state with specificity why they're asking for the reservation later on, that makes the reservation sort of meaningless, especially for pro se litigants. Thank you.
Okay. Any questions? the patron or anybody. Okay, yeah, Senator Short.
Just a remark, I actually thought this was the policy, and I haven't practiced in this arena in years, but I thought that is what everybody thought the policy actually was. And I thought there was some case law on it. Perhaps I'm mistaken, but it does seem to me that this is, regardless of all that, this would be the appropriate policy going forward. So I move to report the bill.
Second.
Okay. I thought that was a policy too. All in favor of the motion to report Senate Bill 432, vote aye. All opposed, no.
Ayes 12, noes 2.
12 to 2. Senator Shervill, your bill has been reported.
Thank you. Last one.
Before, I'd like to put Senate Bill 433 off. I have some questions about that.
You want to take a bite for the day?
Yeah, but
That's
take it
fine
off
with me.
today. I have some questions.
I don't have any witnesses
Yeah.
for that. That's fine.
Okay. Senate Bill 378 is Senator Bell's bill. Has that been sent to the Criminal Law Subcommittee? Okay, it's already Criminal Law Subcommittee. And what else do we have? Is there something we're missing? Have we gone through the docket? Okay, if nothing else, the committee will rise. Thank you, Senator Stewart.